All right. Good afternoon, everyone. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, February 22nd, 2024. We have 15 bills on the docket. We're going to start off with Senate Bill 479, and we're going to invite our distinguished Lieutenant Governor up and the governor's cabinet and staff. Welcome.
Well, thank you very much, Chairman Smith, Vice Chair Waldstreicher, and members of the Judicial Proceedings Committee and your hardworking staff. I'm Aruna Miller, Lieutenant Governor of Maryland, and I'm testifying in support of the Moore-Miller administration's Senate Bill 479, the Maryland Road Worker Protection Act. Across Maryland, on any given day, there are approximately 300 construction work sites with over 1,000 roadway workers. Last year alone, there were 1,200 work zone crashes. That's over 3 crashes every single day. So for the people who work on these sites, it's not a matter of if they will see a crash on the job site, it's a matter of when. I've spent 25 years in my career as a transportation engineer, and I've been on these construction work sites. And let me tell you, and I know every one of you knows this already, it's an incredibly dangerous job to be on these sites. Senate Bill 479 protects the men and women who place themselves in harm's way on the front line of service. It is a moral imperative that we protect road workers who provide critical public service. This is how we make Maryland a state that serves. In March 2023, the work zone crash on I-695 in Baltimore County instantly killed 6 workers. This was the deadliest work zone crash in Maryland's history. 2 of the victims were a father and a son, Malon and MJ Simmons. I'm honored to be joined by their loved ones today and would ask that the Simmons family please stand and be recognized for their commitment to increasing work zone safety. Thank you. Governor Moore established the Work Zone Safety Group. We assembled a diverse team, including MDOT administrators, highway engineers, safety inspectors, law enforcement, labor, and construction workers. We are deeply grateful to have had the participation of Senator Ariana Kelly, as well as E&T member Delegate Ziegler. The Work Zone Safety Group concluded that reducing speeds alone was not enough. Instead, we needed to bring a culture change in driving behavior comprehensively, and that the strategy must include education, engineering, and enforcement. Senate Bill 479, the Maryland Road Worker Protection Act, focuses on enforcement. The use of speed cameras in work zones was first approved by the Maryland General Assembly in 2009. Our administration's bill utilizes technologies that were not available 15 years ago and strengthens enforcement in order to change driver behavior. Senate Bill 479 removes the requirement that speed camera be manned by a person physically present at a work zone. Instead, we're asking not just it to be manned, but also include unmanned. The proposed bill permits the deployment of multiple speed cameras across the entire span of a work zone. Many of you know that our construction work zones can last several miles. So research shows that work zones equipped with multiple speed cameras demonstrate greater effectiveness in modifying driver behavior, leading to reduction both in speeds and crashes, compared to work zones employing only a single camera, which only impacts drivers at a singular location. Senate Bill 479 also purpose is to change driver behavior and not to collect revenue from drivers. That is not the purpose of this bill. The bill includes a provision that limits drivers to 1 citation for speeding violations throughout a work zone, even if the driver is caught by multiple cameras. Maryland currently maintains the lowest work zone citation fee nationwide, set at $40. Senate Bill 479 proposes raising this fee to $290, aligning it with the citation amount issued by law enforcement when a driver is pulled over for speeding in a work zone. Senate Bill 479 requires that the revenue collected through the work zone speed cameras be reinvested into highway and work zone safety initiatives. Finally, we're proposing an amendment that would expand the protections of work zone speed cameras to county and municipality maintained roadways and require that local governments to reinvest any revenue generated to only local public safety and roadway safety programs. The people of Maryland stand with us in their support for these actions. MDOT conducted a survey in September of 2023 to solicit feedback from the public on work zone safety. Out of the more than 2,200 respondents, 66 expressed that higher fines for speeding within work zones would effectively influence their driving habits. But we know that enforcement alone is not enough to bring a culture change in driving behavior. It will require education and engineering too. MDOT has already invested $500,000 on an aggressive public safety awareness campaign to educate drivers and are engaging the sports community and students to get the message out. Through innovative engineering solutions, MDOT is also using cutting-edge technologies to reduce direct interactions between road workers and motorists, while enhancing safety through the implementation of green light systems that the General Assembly recently approved, as well as other tools. We have the capacity to spark a cultural shift in driving behavior because we've done it before. The culture surrounding drivers wearing seatbelts looked very different 35 years ago, but through education, engineering, and enforcement, the culture changed. And today, seatbelt usage exceeds over 90% compliance. We can do the same in work zones. And here's the thing, the impact of the culture change that we're aiming to create with Senate Bill 479 goes beyond just work zones. Safer driving in work zones will lead to safer driving everywhere. By intercepting dangerous driving habits, we can lower the number of crashes and fatalities across the state of Maryland, making a safer state for road workers, motorists, passengers, cyclists, and pedestrians. I ask for your favorable report on Senate Bill 479, and I'm happy to take any questions. Thank you.
Thank you, Madam Lieutenant Governor. We're gonna, is anyone else going to present on the panel or just here for questions?
Yeah, I think.
Okay, we'll hear for the rest of the panel and then we can take questions at the end. I know we have a couple of folks who want to weigh in.
Good afternoon, Mr. Chairman and members of the committee. For the record, my name is Christine Iser, Administrator of the Motor Vehicle Administration, and I also have the honor of serving as Governor Moore's Highway Safety Representative. We're proud to be here today with many of our longtime safety partners in support of Senate Bill 479 and to reaffirm MDOT's commitment to ending all roadway fatalities and serious injuries. Unfortunately, too many families have to be in that category of victims. And in 2023, we've seen our highest fatality rate since 2007 with over 600 fatalities. And that includes our 8 work zone workers. And so these statistics, as we know, are not just numbers, but their families and communities are impacted forever. As we look at work zone crashes, the contributing factors are really the same factors we see in crashes throughout our roadways. It's people continuing to get behind the wheel while they're impaired, it's driving with excessive speeds, it's distraction on their phones, failing to move over for all stopped vehicles on the shoulder, and neglecting to ensure that all the passengers are buckled. But obviously in a work zone, we know these are even more dangerous behaviors that unfortunately lead to tragedies like we experienced. And I want to make a fine point that these are all choices. A driver makes a choice to get behind the wheel impaired or not to buckle up that seatbelt or to drive excessively at high rates of speed. Unfortunately, other people often suffer the consequences of those very poor decisions. MDOT has an active highway safety campaign. It's called Be the Driver, and that encourages motorists to practice safe driving behaviors regardless of where they are, and really trying to reach that goal of 0 fatalities. I really want to thank the governor as well as the lieutenant governor for convening the work zone safety working group and taking this really bold step to protect all of our workers. Over the past year, this 29-member committee developed a wide range of recommendations based on 2 themes. The Driver Behavior Subcommittee, which we thank Senator Kelly for participating in with us, focused on improving driver education around the work zone and recognizing the individual's role in creating that culture change that Lieutenant Governor referred to. The Roadway Operations Subcommittee focused on planning, design, and operations in the work zones themselves. Among the administrative recommendations that the Moore-Miller administration has already started implementing include updating the driver manual to include the focus on work zones and appropriate behavior, and including those flashing green lights that the legislature recently authorized. Aggressively partnering with all of our stakeholders to reach every community group and demonstrate the simulation of crash and the consequences of what happens. Expanding our safety marketing, as Lieutenant Governor said, we're really excited about some things you'll see coming soon related to work zone safety as we approach that month. Updating training and certification to ensure that we're using the best practices as a state. That includes morning huddles, really making sure the workers are also constantly reminded, because you're in that work zone all the time. So it's really easy to forget those common best practices. And then looking at innovative equipment. How can we use technology to make our workers safer? With Senate Bill 479, the state will be able to go further and reinvest our valuable resources towards highway safety programs using education, engineering, and enforcement. We know the primary causes of crashes and fatalities. It's time for this to change. It's time for us to come together. The message is simple. Changing the behavior of drivers is everyone's responsibility, so we don't continue to needlessly lose these lives on our roadways. Senate Bill 479 will improve work zone safety as well as safety throughout our state and save those lives. And I ask for a favorable report. Thank you.
Excellent. All right. Thank you very much. We'll now turn to the committee for questions. Senator Sidnor.
Thank you very much. And anyone on the panel can speak to this, but the Lieutenant Governor had mentioned an amendment. And I'm wondering, is that amendment being put in, is it with regards to Mako's testimony? And if so, how is that supposed to work? They're, according to their testimony, they're seeking, what does it say? Parallel authority. What is it that they would be able to do different? I mean, and anyone can speak to it.
Sure. Senator, thank you for the question. So my understanding right now is the way the law is, local municipalities as well as county governments can utilize work zones speed cameras, but any revenue that's collected goes right back to the state. What our amendment says is that the locals can continue to utilize these speed cameras only within work zones and only on roadways posted 45 miles an hour or more, and that any revenue collected would go back to the local government to go directly into roadway safety programs.
Thank you very much.
Sure.
Thank you, Mr. Chair.
And could we have
Lieutenant
the
Governor, I
witnesses?
can't see you.
Yeah, sorry. Could we have the witnesses come to the podium?
I don't know who wants to answer the question, so I just have a couple questions to ask. Thank you for bringing the bill. Thank you for discussing this measure, because it's obviously a very important measure in protecting our workers. So the bill, when I'm reading it, it constantly makes reference to like the driver, but this actually goes to the registered vehicle owner, not the driver. Is that correct?
That is correct.
Okay. And so, and we're jumping from, we're expanding this opportunity to be manned and unmanned speed control measurement devices, correct? And so is there a calibration period that's going to happen with these? Because I know as a radar operator, you have to properly calibrate your equipment before and after every shift. And there's going to be, is there a requirement then on a daily basis that the people go out and make sure that this is functioning properly so that we're not having citations sent out?
Senator Foldo, first off, thank you for your service to our state
Oh, thank you.
and the service you provide in protecting Marylanders as a law enforcement officer.
Thank
At this time, I'm going to turn that question over to Administrator Nizer, who's probably better able to address your
Sure,
question.
thank you. I appreciate it. Thank you. They're probably going to want you to stand up, ma'am.
Yeah, and I'll just reinforce what the Lieutenant Governor said, that all automated enforcement goes to the registered vehicle owner. So this is just consistent with what is
Sure.
existing practices for these type of programs. There are calibration requirements for all of these devices. I think SHA can probably speak to how frequently that happens, but yes, they are required to be calibrated
For
on a
the
regular
unmanned
basis.
ones?
Yes, any of the devices are.
Well, I know
required
the
to be
manned ones they do because they're actually,
Do you want to come back?
I just want to make sure that we're not having erroneous letters sent out or something, citations.
Thank you. For the record, I'm Terry Seuss, Deputy Administrator for Operations with the State Highway Administration. So right now, our current contract with the vendor for manned cameras is calibrated. The technician there is there every day
Sure.
when citations are being issued. So we would have to do an amendment to a contract if the bill is passed. We'd have to look at the technology that is being provided. We would do test runs with the vendor to ensure that it is accurate. And then we would seek, based on the technology, the type of calibration that would be needed. We anticipate it would be on a daily basis
Okay.
or a regular basis, again, depending on the technology.
Great, thank you. And then my next question is, you know, we're talking about work zone safety for these employees, and it's a very important measure. And I know that this body, and I was one that had expressed concerns before, because we're talking about active work zones. And so the term active work zone, is my understanding, comes out from the day that the shovel is in the ground, regardless if there's personnel there at the time of the offense. Is that still going to be how this model is rolled out on the unmanned portion? It'll be 24 hours a day, regardless if there's a car there or not, 24 hours a day. I'm sorry, regardless if there would be a manned speed measurement device, which obviously I think people have, better or worse, have become accustomed to look for.
Sure. So yes, very good question. Thank you. So we do issue citations right now. Could be up to 24 hours a day, and we want to enforce safe speeds through a work zone. Sometimes that work zone, concrete barrier, restricted lanes, or other issues presents a safety concern to the drivers themselves, not only the workers. So we do issue citations up to 24 hours a day. We also have nighttime operations where our workers
So
are
that
out at night.
practice will continue.
We anticipate that. So we would look at each project and try and evaluate that based on the expected work hours. And again, the safety concerns for drivers passing through that work zone.
So okay, I appreciate that. My question is because if we're going to expand it to unmanned times, then obviously there's a cost savings overall. No vehicles, no personnel we're paying. It's a significant decrease in maintaining this program. But if we're looking at active work zones, then I thought there was some discussion, and maybe I misunderstood our discussion, that this was the unmanned ones were going to be solely predicated, because they could be, around actual boots on the ground times. Is that inaccurate then?
Senator, yes, our discussion is right. As Deputy Administrator Seuss just said, the manned cameras, as well as the unmanned cameras, there are certain situations that warrant them to be there 24/7, again, to protect the drivers.
Sure.
Whether, like bridges, for example, we're
Exactly.
doing construction there, it's really narrow. We
Mhm.
got to have it there the whole time.
Sure.
Just to protect them. But by and large, for the ordinary construction zone sites, my understanding is it is not that we would have these unmanned cameras 24/7. They would be deployed when there are workers on the site.
Yeah, and I
And
appreciate
in
that.
situation that
Thank you
it's
for that
dangerous.
clarity, because I thought that was our discussion.
Yeah, that's
So thank you
exactly
very
it.
much, Lieutenant Governor. And then I thought we had, I'm curious why we're looking to eliminate the 30-day warning period. Because that's usually set up prior to the groundbreaking occurring, that you could actually, or like once they get everything out, or is that always the first 30 days? Like, why wouldn't we do like a 30-day notice ahead of time with these cameras to notify people, hey, because they're not manned, hey, this area is, they're setting up for construction to begin, to kind of do that education we're talking about, that driver education, and and putting that in their mindset. Is that something that's considered in this? Because I don't see anywhere. It looks like they're getting rid of the 30-day warning period all of a sudden, and you can just issue from day one.
So Senator Folden, I'll go ahead and respond first, and then I'll
Sure.
open it up to Administrator Nizer. So I think when the bill was originally written in 2009, it was that speed cameras were going up across the street and drivers weren't aware that the speed camera is there. Look, most drivers, when they're going by construction site, they should be aware that, hey, you should be slowing down. This is an unusual circumstances that, warrants a little bit of your behavior changing along that location. So the idea behind removing the 30 days, a couple of things. Number one, in order to even issue a citation, you have to be going over 12 miles an hour more than the posted speed limit, right? How much more warning do you need than 12 miles an hour? So we feel that removing the 30-day, again, when construction site is up there, you got the equipment there, the orange is out there, people should be fully on board that, hey, I better slow down here. And we're going to have signs up there saying, hey, here's the camera, it's posted, we're going to, do this. But, that's kind of the thought pattern behind it,
Sure.
that this isn't something that's going to be there indefinitely.
Yeah.
It's only going to be there temporarily during the construction site.
Would you be amenable to the idea of putting in, instead of a 30-day warning period, a 30-day notice ahead of time, posting such changes forthcoming?
She will go ahead and
Thank
talk about that. Yeah.
So maybe if I can just add to what the Lieutenant Governor said, there's so many different work zones throughout the state that some of them that are larger, they may warrant that notice period ahead of time to give drivers more an expectation that things are going to change. But with the number of work zones that happen, it's not necessarily appropriate. Many of these are short-term work zones. In order to be able to use the cameras, that requirement for notification is in place, which then restricts our ability to be able to place those cameras. And so that's why I think we were looking for some additional flexibility to be able to do it where appropriate, still providing appropriate notification. And with the additional funding that we've got from an outreach standpoint, we're talking about not just the signage in work zones, which obviously is very important,
Sure.
but also billboards where they're nearby a work zone location, so we can get that message out before a driver even comes in. So that's the thought process. As you indicated earlier, every work zone is a little different.
Sure.
So providing administrative flexibility there.
I love the idea of what we're talking about here. I know that, like the Lieutenant Governor said earlier about, these zones that maybe I worry about the rollout and notification, because I can tell you in 2009, after my beloved Philadelphia Eagles lost in the playoffs, and I was on my way back from Philadelphia, it was like 2 a.m, and I was on 695, and it looked like a bomb went off behind me, because it's 2 a.m, and driver behavior is you're going to drive at a speed that's comfortable. There was no flashing amber lights, there was no flashing green lights, there was nothing. It was a very dark, wide open road with nobody on there, and one of these citations, I got a citation to add insult to the injury of my team losing. So
as a Ravens fan, I can relate.
I know. Thank you. So my question is historically, when speed studies are conducted by law enforcement or SHA, it's what is it, that 85th percentile or the 80th percentile, whatever that number is, that we like to look at, because drivers will drive at a speed that they're comfortable driving in the lanes provided, because lane widths are wider on the interstate, so it looks like you got a lot more ability to stay in your lane, but they're compressed in work zones a lot of times when you're doing bridges and the like. So I understand that process. I just get worried about the notification of people so that we're not just flipping this on and all of a sudden, you know, there's a litany of people jamming on their brakes because all of a sudden they see the lights going off like they're walking on the red carpet.
No, we definitely want to avoid that as well. Speed differential is what you're referring to, and that's really what causes the crashes, right?
Yes.
Vehicles
That is
traveling at
exactly
different
what causes
speeds
it.
that tend to interact
For
with
the
each
most
other,
part,
let's
yes.
just say.
Yes.
One of the significant causes there. So I think that, as Lieutenant Governor said, we definitely want to make sure that the implementation, that everybody is aware of this. So we've even talked about, as citations are given, assuming the legislation moves forward and there's an agreed upon fine level, we would notify customers right away. So even as you're getting a citation today, it might be $290, but effective this date, it's going to be higher. So we're already thinking about how we, through every mechanism we have as a state, can do public education, the outreach campaign we talked about, the physical notice. And so this is just one avenue. It's not to say that SHA would not notify in a work zone in particular, if that was appropriate
Sure.
based on the dynamics of
And
that work zone.
is there a way, I appreciate your answer and I appreciate what you just said because it prompted me to think about when you said the 290 fine. Was there ever any consideration to a tiered fine schedule by either number of offenses or by the speed you're going at the time of the offense? Because the Maryland fine schedule for law enforcement is always tiered along the speed that you're traveling at the time of the offense.
Mhm.
So I'm just curious if you were 1 to 9 miles an hour over or whatever, and then from 10 to 19 and 20 to 29 miles an hour, was there ever a consideration to implement a fee schedule associated with the actual threat that is given? Because someone going 12 miles an hour over is wholly different than someone that's going 35 miles an hour.
No, I couldn't agree with you more, Senator. I think what we're doing with this bill is no different from any unmanned speed cameras that are out there. I don't know, does the state have a tiered process for speed cameras that are unmanned?
So I can tell you law enforcement does, but not the speed cameras.
Right.
Like the speed cameras would be,
It's station.
it's $40, but we're
Yep.
talking about a $250 additional. So I'd like to also see what the amount of revenue was from the $40 annual fees or annual assessment violation to what is the projected, by the number of those citations, you can forecast out an additional 250 per. And I thought all this was going back into education and the
Mhm.
work zones and all that, but now I see that there's 25% of the residuals, which could be a large amount by the number of volume of the citations. 25% now goes back to MSP for cars and I guess other equipment for
That's
them
correct.
being in these areas.
That's right,
Okay.
because they're also part of the construction zone activity scene, right?
Sure.
The police are there, and as a result of that, some of this funding goes to be able to pay for the equipment that they need to serve these construction zones. But again, going back to having a tiered level, and yes, we are proposing $290 citation. But Senator, you being a law enforcement officer, you understand this better than anyone, right? Look, number one, they're violating the law when they're exceeding the speed limit. Number two, they're putting everybody in the roadway in danger. The Simmons family lost a father and a son. There is no amount of money that can equate to the loss that they'll feel for the rest of their life. So
But
I
they're
think,
not getting this money.
no, they're not getting
So-
this money.
Correct.
But what
mean,
I'm
I
saying
feel-
is, when we, the driver, as Administrator Nizer pointed out, when we make the choice to exceed the posted speed limit and decide to endanger everyone on the roadway, there's a price for that.
I appreciate that response, Lieutenant Governor. And like I said, I don't have a problem. I think the bill is warranted. I just think there's some things that we could do a little better on it.
Sure.
So I appreciate your time. I wish we had this type of lively debate on other criminal behaviors, like, I don't know, illegal firearms, but we don't want
All
to.
right.
So I appreciate your time, Lieutenant Governor.
Thank you.
Thank you.
Thank
Thank you
you.
very much, Senator Folden. Let's move on to Senator James, then Senator West.
It is so nice to see you, Lieutenant Governor, and I enjoyed our time in the House together, and it's very
Me
nice
too.
to see you in the position that you're in. And thank you for bringing this bill. I don't think anybody in Maryland was not aware of the tragedy of last year. Just shocking.
Yes.
And I've told my whole family, especially my children, don't, whatever you do, do not go off to the side of the road. If you can eat that vehicle even off a ramp, just because I've known for a long time how incredibly dangerous, of course, work zones being the worst, because so much going on there, but even disabled vehicles, you hear about police officers being killed also when they're trying to, retain a driver, truck drivers. It's just horrific. So and I've noticed on 95 over my many years that I see people driving faster than I've ever seen them before on a more regular basis. So my questions are not about the intent or purpose of the bill, just trying to figure out how to do what we need to do, which is change reckless driving behavior.
Yeah.
But also make sure that we have public support once the program is up and running, and anything we can do to make sure we can keep both of those high in our minds. So just a couple of questions for myself. I know you all mentioned that report, and my staff may not have gotten it, but could you all make that available, the report? You mentioned the two
Sure.
subcommittees. Okay. Are there, and a lot of these questions, as I usually tell people, follow up, you don't have to answer here, so we can let other people ask questions. Other states that have done something similar, either with the cameras, the multiple cameras, even the idea of multiple cameras, but within a 1-year period, if you're caught. And then also, most importantly, where I think I might hear from my constituents is if they get a ticket in the 290 to 1,000 range and, believe that maybe that was set in error, and how do I respond to this? So the other thing I'd be interested in is if this is happening elsewhere, especially with these very high citations from an unmanned situation, has that resulted in significant behavioral differences in drivers? Because that's, as I understand, this is not about raising revenue, but about changing behavior. So we want to make sure that whatever we do, it does change behavior. And then again, maybe it's in the report or elsewhere, but if you could get back to me on how much money you think might be generated by this program. I'm sure as the money decreases over the years, that's going to be something we're happy about, that we
Absolutely.
don't have a revenue source, right? That's what we really want. But just to let me know what you think that might be. Let me see. I'm wondering about this, since what we really want to do is change driver behavior as quickly as we can, as consistently as we can. Is there any thought behind more signage? I know you're mentioning it, but I'm wondering if I would feel more comfortable it was in the bill, to be honest with you, that we were going to make real efforts, whether it's the lights that you go under on 95, but there's lots of work zones on state roads that don't have that ability to have that, big sign, but lots more signage leading up to this work zone, because I want people to change their behavior, and would rather them do it when they see a sign that says, guess what? In 5 or 10 miles, if you're going this fast, you're going to get a $290 or $1,000 ticket, right? And you don't want to distract them with that, but anything that I wanted them to change the behavior and have as much warning and notice, appreciating that 30-day notice may not work anymore, but some stuff, in addition to your campaigns and education, drivers on the road. We have a lot of out-of-state drivers, so they're not going to be, perhaps this education might not be available. And I think the last thing I wanted to ask about, sorry, just give me one moment, I was writing notes. Just let me check. Sorry, hold on. The last thing, and I tried to read the bill quickly. Could you just explain to me, my county has been rather loath to put in red light cameras, speeding cameras, basically because we have a belief that our constituents are going to be very deeply suspicious that they're not accurate. And then you can't, how do you fight a machine? So I'd like to know a little bit more about the logic behind giving the locals this authority as well, at what standard equipment they'll be required to do. And then a little more about the quality of the equipment and the assurances you can give us that they really are accurate. They really do capture driver behavior. That, things are not going to go in error. As you all know, when we started red light cameras, in certain jurisdictions that the equipment was faulty, excessive tickets were going out and the like. All right,
Okay.
thank you very much. It's a lot.
Sure.
You don't have to, I just like the.
I could touch on some
Oh,
of it,
sure,
Senator
but
James, if that's okay.
okay.
Is that okay, Mr. Chairman? Okay, so you mentioned about other states. Are
Yeah.
they deploying something similar to this where they're using multiple cameras in a site? Yes, they are. But actually, we have survey that shows that it's much more effective as opposed to having a single speed camera at a location. And we're happy to share that
makes
information
sense.
with you. The next, as I understand your question was the $290 citation and how it varies to up to $1,000. How are they going to get this notice? So I think Administrator Nizer kind of touched upon it earlier, and to your point, Senator Folden, is that one of the ways in which MDOT can give sufficient notice and warning to drivers is once, should the bill pass through and it gets implemented June 1st, then take the next 6 months to anybody that's violating the speed. They get a notice saying, hey, you exceeded the speed limit. We're giving you a $40 citation, but know that we can give you $290 and it's going to go into effect 6 months from now. If we catch you
I like
again,
that.
you're going to get a $290 citation. So that's one way in which we can ease it into the public that this has come, because we understand it is a substantial increase. But again, enforcement is one of the biggest ways in which we can change driver behavior. And the most effective way is to have a live law enforcement officer at the scene. But we believe having these unmanned cameras removes, another opportunity for a driver to hit, the law enforcement officer. That's one less person you're exposing in a dangerous situation like a construction site. The money generated. So when it comes to the locals, right now, the locals already have the authority to put the speed cameras along work zones. They already have that authority. The only difference now, my understanding, is that they don't deploy it because the money generated, the $40 citation amount, comes directly back to the state. And they're like, how does that help us when it's going directly to
Well,
the
that doesn't
state?
speak well for locals if they're worried about safety, does it? But anyway.
Right, you would.
All right.
Well, I'm not going to
another
speak to all of them.
discussion.
So what this bill says is that we understand and we want the money to go back to the locals so they can use that to make their roadway safer. That money cannot be used for anything else but, creating more safer roadways. So that would be that. Now, you talked about more signage. Yes, the State Highway Administration has the flexibility to add whatever signage and as much warning as possible. And I think if we hear comments from the public, hey, we need to see more. I didn't know this was happening. Certainly, if they get a citation, they could go to the circuit court judge and let him know, look, the sign, I was confused. I don't know what was going on there. And possibly get the citation amount reduced or eliminated. But certainly SHA will have adequate signing and they follow, national standards on how the signage is posted for any construction zones. But if there's other ways that we
Yeah.
can make it better, I'm sure
Yeah.
they'd be more than open to that. Let's see. Then you mentioned the locals having the authority for the speed cameras. How are they going to calibrate it? And how do we know that they're doing the right thing? I think the idea is that they do the same exact thing the state is required to do under this law. And Administrator Seuss talked about that. When it's a manned camera, it's calibrated every single day. Unmanned cameras might not be necessary to calibrate it every single day, but whatever, frequency that's needed, that's what we would
But you wouldn't
expect.
be
the
averse if
locals.
we made that a little clearer in the bill, that we want the locals, if they're gonna use this, to follow best practices and the standards that the state is leading with.
Yes,
Okay.
okay. I didn't know if the
I
two
think
of
that-
you wanted to add, sure. Go ahead.
Thanks. The other thing I will say about the fine amount that I don't think we've mentioned yet is frankly, we looked at the precedents already been set by the legislature with the automated enforcement for school buses, which is also a significant fine amount to $250 for that automated enforcement. And that's something that's passed recently. So certainly the working group looked at that as kind of precedent setting in nature. And the fact that school zones and work zones should be equated, that, you know, the same way we look at a school zone, we don't want to hurt any precious child. We also don't want to hurt our workers.
Does 250 help bring down incidences of people doing the wrong thing, and
There was a sense from the law enforcement members and some other members of the committee that there has been a change in awareness in school zones. And I know we have still had some crashes. I don't want to diminish what's occurred. But there was a sense that people look at school zones differently. And I don't know if it's because of the automated enforcement or it's just a general awareness of those school zones. You also asked about decreasing speed. I think there's a lot of great examples. I know on the city, the JFX is one that's gotten a lot of attention with the speed camera that they've deployed fairly recently, and really the number of citations have gone down in a very significant way. I know SHA has experienced the same thing where they see a decrease in citations. They do clearly change behavior and people's awareness about it. And to add on the sign, I know one of the things we talked about is putting the fine amount on some of the signage. I know SHA has to follow certain guidelines, but where we can, putting it front and center. So there is nothing, we're not trying to hide anything in terms of what that fine amount is. We want you to know what it is. And then the ability to appeal. I just wanted to reemphasize that not only do you have the ability to go to the courts, you also get that photo of your tag number. If it's not the right tag, if there was a misread by a small percentage, you know, there's an administrative ability to go to both us and SHA to have that removed because it was done in error. So there are multiple mechanisms through which somebody can get remedy if there was a misread of a tag for whatever reason.
Thank you. Thank you, Mr. Chairman.
Thank you very much. Administrator Nizer, you are relatively familiar with the committee, but Madam Lieutenant Governor, I know you're not a frequent flyer here in JPR, and God bless you for that. But thank you for bearing with us with this. It's a little bit culturally different here, so a lot of questions. This is not unusual for the committee, so thank you for bearing with us. Senator West.
Thank you, Mr. Chair. I will have relatively fewer questions, but it's always great to see the Lieutenant Governor. We served together in the House of Delegates, as did Mr. Ludke and me. So it's like old home week in here today. So I want to congratulate the administration for this bill. I think I sponsored 14 of the 16 administration bills this year. This is one of them. I think it's a great bill. I have a bill coming up next week, which would require the State Highway Administration to put speed cameras on the Baltimore Beltway. Speaking of which, I'd like to talk to the lady from the State Highway Administration after the bill hearing is over about that bill. And my bill was patterned after a bill we enacted a year or two ago to authorize speed cameras on the Jones Falls Expressway. So those cameras are now in place, and I drive up and down the JFX, and I can tell you it's palpable that the speeds are lower today on the Jones Falls Expressway than they were before the speed cameras. They have done their job. People are now observing the speed limits on the JFX. But the one thing about the JFX that they have that I don't see in this bill is a requirement that electronic cameras or electronic signage be put in place shortly before the speed cameras, letting you know what your speed is. We've all seen those cameras. They're on the Bay Bridge, they're on the JFX, there are other places around the state. So you would know if you're just driving without thinking and your speed is crept up, and all of a sudden you see the camera, it says your speed is 65 miles an hour, and you know the speed limit is only 50, you know, uh-oh, I've got to cut my speed down. It gives the driver a little more warning, a little more reason to tamp on the brake rather than get these high tickets. Have you thought of putting similar language into this bill? Requiring those sorts of electronic cameras to be posted near the areas where these speed cameras are going to be located?
Senator West, that's a great recommendation, and thank you for your support of the bill. And I'll turn it over to Administrator Nizer.
I feel like you all are very in tune to the conversation the working group had, because that was the exact feedback we got from the members of the working group, which, as I said, we're a very diverse group. They really felt like those feedback signs were incredibly effective. And I know SHA and MDT already use those signs in work zones. I don't think we thought it was necessary to put it in the bill because it's a kind of best practice and it was part of, again, the recommendations for what signage should look like. But you are exactly in line with where the working group was in terms of the effectiveness, because, you know, somebody maybe is driving thinking about something else, even though you should be paying full attention, and then it gets away from you. And that
It's
reminder
a
of your
beautiful
speed is
day, you're
helpful.
looking at the cloud, you know,
That's-
and all of a
that's
sudden you
very
realize you're
helpful,
driving
yes.
too fast.
Yes. So we completely agree. And again, it is a current practice of SHA as well as MDTA. We didn't think it was necessary for legislation, but it was a recommendation of the working group in terms of using those signs to more effectively notify the driver about the speed they're currently
If
going.
we were to add an amendment to the bill for requiring that sort of signage, would you push back? Or would you think this is something the governor could accept?
Just as a parenthetical, every camera bill we've passed out of here, we've had that language in there. Just as.
Yeah, I think that was the intention anyway,
Yeah,
to
yeah.
put those signs up. So I don't think it's inconsistent with where we are on.
Terrific. Thank you very much.
Okay, further questions from the committee? Thank you all very much. Thank you. I'll now bring up the second panel. We have Maryland State Police Lieutenant David Ryan, Maryland Transportation Builders and Materials Association President Mike Sakata, and State Highway Administration Chart Senior Technician Howard Bostick. You say the members. Those were good, very good questions. I thought it was good debate. Thank the members for the questions. So go ahead.
Thank you. Good afternoon, Mr. Chair and esteemed members of the committee. I'm Michael Sakata at the helm of the Maryland Transportation Builders and Materials Association, championing the cause of over 30,000 workers who are the backbone of our state's transportation infrastructure. And today I stand before you not as a representative of an association, but as a voice for those who risk their lives daily in Maryland's work zones. I say work zones, but they're war zones right now. Our urgent plea is for the passage of Senate Bill 479, the Maryland Road Worker Protection Act. This is a beacon of hope for enhancing the safety for our dedicated workers. The tragic event, as mentioned on March 22nd, served as a grim reminder of the perils faced by our workforce. It's a clarion call that we no longer can ignore. These workers are not mere statistics. They are fathers, mothers, sons, and daughters, some of whom are here with us today, whose lives are invaluable and their safety is non-negotiable. The leadership of Governor Moore and Lieutenant Governor Miller in spearheading this bill is commendable. However, it's our effort, our collective responsibility to carry it across the finish line. Senate Bill 479 is more than legislation. It's a commitment to valuing life above all else. It proposes stringent penalties for speeding in work zones and modernizes enforcement, directly addressing the reckless drivers that endanger our workers. We heard already the 1,200 work zone crashes in 2023 alone. We have got 300 active work zones today. Each incident, by the way, is a reminder of the urgency with which we must act. This legislation is a chance to make a definitive stand for the safety of those who build and maintain the roads we travel on every day. I also want to comment this bill doesn't change that threshold that you're considered speeding if you're going 12 miles over that posted speed limit, which is a lot. I mean, I implore you with the utmost sincerity and urgency to cast a favorable vote for Senate Bill 479 to change driver behavior, and let's honor the lives of our road workers by ensuring their safety is a priority. Your support can save lives and send a powerful message. Thank you for considering this life-saving legislation.
We'll take questions at the end of the panel. Thank you.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the committee. I'm Lieutenant David Ryan, Commander of the Maryland State Police Traffic Incident Management Section. I've been a Maryland State Trooper for over 21 years and have served in various field command billets since 2013. I also served on the Lieutenant Governor's Work Zone Safety Committee. I am pleased to be here to provide a law enforcement and safety perspective relative to Senate Bill 479. As a commander of TIMS, I often respond to and supervise collision scenes that occur within highway work construction zones. Work zones provide a unique and challenging environment for law enforcement. Citizen safety, worker safety, as well as officer safety is paramount. As you know, many work zones are currently staffed with a state trooper to provide scene safety and a visual deterrence. These troopers are specifically trained to work within these zones. Recently, the State Highway Administration provided funding for an additional trooper to specifically provide enforcement in and around the work zone. Additionally, Colonel Roland Butler, Superintendent of the Maryland State Police, has tasked each barrack across the state to conduct regular work zone safety initiatives within their respective counties. In 2023, the Maryland State Police conducted 276 of these initiatives, provided 9,214 hours of enforcement, made 8,124 traffic stops, issued 11,489 citations and warnings, made 51 criminal arrests and 45 DUI, DWI arrests in the work zones. This work is and will continue throughout 2024 and beyond. Many of these collisions occurring in the work zones are related to three factors: speeding, distracted driving, and impairment. Enforcement combined with education often leads to a reduction in violations and provides for safer Maryland roadways. Thank you for the opportunity to be here today. I'm happy to answer any questions you may have. Thank you.
Good afternoon, the committee. My name is Howard Bostic. I work for Maryland State Highway Administration Emergency Response Technician for CHART. I was a member of the Driver Behavior Subcommittee work group led by Administrator Nizer. I bring a unique perspective to the work zone, and as my office are work zones, and I am an emergency response tech, respond directly to incidents that occur on the roadways and the interstate, assisting stranded motorists, providing traffic management, and supporting law enforcement and fire rescue department on crash scenes. I have a firsthand look at the recklessness and distracted driver behavior motorists when they travel through our work zones. People continue to speed, don't move over, and makes our job even more unsafe already than it's already are. Unfortunately, on December 22nd, I was involved in one of them work zone crashes. I was responding to an accident rollover on the JFX. Got there, set up, and put all the cones out. And this van came down and hit my truck at 70 miles an hour. The crash was scary. My life flashed before my eyes. And I hope you will vote for this bill. And I just want to thank the governor for putting the bill out there, the lieutenant governor, and Administrator Nizer. Thank you for having me.
Thank you very much, Mr. Bostic. Questions from the committee? All right, seeing none, thank you all very much. Thank you for being here. All right, now we'll hear from Mr. Brown, Marshall Brown, Debbie Jennings, James Deriu,
Chair Smith, Vice Chair Wallstriker, esteemed members of the committee, I extend my gratitude for the opportunity to offer verbal testimony in support of Senate Bill 479, the Maryland Road Worker Protection Act. My name is Marshall Brown, and I serve as the Director of the Laborers, Employers, Cooperation, Education, and Trust in the Mid-Atlantic region. LESIT is a joint labor management association within the construction industry affiliated with the Laborers International Union of North America, or LIUNA for short. Our mission is to address worker issues with the welfare and safety of our workforce being top priority. Today, I stand before you in support of Senate Bill 479. This legislation is crucial for protecting our workers. High-speed work zones have taken a toll, as seen with the tragic loss of lives on 695 recently. Senate Bill 479 offers enhanced safety measures that can save lives and ensure that every worker returns home to their loved ones at the end of each shift. The measures include those previously mentioned before me. On behalf of LESIT, LIUNA, our contractors, I urge the committee to support Senate Bill 479. Thank you.
Thank you, Mr. Chair, Mr. Vice Chair. My name is Debbie Jennings. I'm the Director of Highway Safety Programs and Special Projects for the Chesapeake Region Safety Council. The Chesapeake Region Safety Council supports Maryland's Road Worker Protection Act. Maryland's roadside workers deserve the advantages that newer technologies, visible enforcement efforts, and stronger penalties that this bill provides. Chesapeake Region Safety Council is a Maryland-based 100-year-old chapter of the National Safety Council. Our mission is to conduct training and education to reduce injuries and fatalities in the workplace, on the roadways, and in our communities. Last year, we conducted over 775 workplace, emergency care, impairment recognition, and defensive driving courses for more than 8,000 students. Our office is in Woodlawn in Baltimore County, located close to the Maryland 695 Security Boulevard exit. Staff members could see the area from the back doors of our building where reconstruction was taking place following last year's horrific work zone crash. 5 of those individuals worked for the same organization that our chapter president, Dave Medeiros, did a safety talk for in January, 3 months before that crash occurred. Our commitment to increasing safety through education and training is truly our mission. The purpose of my presence today is to share that we recognize that there are more E's in highway safety than education, which is the E that I typically represent. Maryland state, local, municipal employees and those working for our contractors are extremely vulnerable, as they must often focus closely on using tools and equipment in a safe manner instead of looking out for the actions of passing motorists. We are advocating for a more visible, comprehensive approach using the additional engineering and enforcement countermeasures listed in this bill, which will increase motorist awareness of the presence of roadway workers and the penalties involved when severe violations occur, resulting in fewer crashes and safer roadway workers. Roadway workers deserve better. Thank you for your support.
Chairman Smith and members of the Senate Judicial Proceedings Committee, my name is James Drew, and I'm testifying today as president of the American Council of Engineering Companies Maryland chapter in support of Senate Bill 479. I'm also an employee owner at KCI Technologies, a full-service engineering firm headquartered right here in Maryland. ACC Maryland is the business voice for our state's engineering industry. We represent nearly 90 firms employing more than 7,000 engineering and consulting professionals, many of whom support Maryland Department of Transportation projects every day. In addition to designing roads and bridges, our members play a critical role in ensuring that projects are built as intended by providing construction inspection services on behalf of our clients. One such dedicated construction inspector was Sybil DiMaggio. With over 15 years of highway inspection experience, Sybil came to KCI to support the implementation of SHA's Transportation Systems Management and Operations Program. TSMO is a program designed to improve the safety, security, and reliability of our state's transportation network. Sybil was just 46 years old when she and 5 other roadway workers were tragically killed in a work zone along I-95 on March 22nd, 2023. Hundreds of inspectors just like Sybil report to highway work zones every day in the hopes that their efforts will improve the conditions of our state road system. Aggressive and distracted driving, including excessive speeding, are unacceptable practices and unnecessarily endanger construction professionals. Expansion of automated speed enforcement systems, such as those proposed under SB 479, have proven to be effective in changing driver behavior. Multiple control systems, remote operated systems, increased signage, and enhanced civil penalties, as proposed in this bill, are important first steps in elevating the concept of work zone safety within the driving public. Our workers deserve to be protected through access to proper equipment and training and every available use of smart technology. In fact, their lives depend on it. We ask for a favorable report on SB 479. Thank you.
Thank you very much. Questions from the committee? All right, seeing none, thank you. All right. Is Brian Sweeney, Miranda Gross, Michael Higgins, and Janet Gronke.
Hi, my name is Brian Sweeney. I'm speaking as a representative of Dimensional Products Incorporated of Finksburg, Maryland, and a resident of Baltimore City. I'm here to express my support for the Senate Bill 479. DPI was established in 2001 with the goal of developing a truck-mounted attenuator, also known as a TMA or a truck-mounted crash cushion. TMAs protect wayward motorists and their passengers, while the host trucks act as barriers and protect workers in short-term work zones. DPI now provides a wide variety of roadside safety hardware. Maryland's economy is dependent on safe and adequate infrastructure. Maryland's citizens depend on our roadway workforce to build and maintain our infrastructure. All of our highway workers have family, friends, and plans for their future. I have known several people who have been injured in work zone crashes. I had met one of the people who was killed in the I-695 crash several times. Work zone technology is evolving constantly and includes barrier and crash cushion devices, distracted driver alert technologies such as portable temporary rumble strips, smart work zone IT technology, queue detection and advanced notification technology, and automated speed enforcement. I urge members of this committee and the Maryland State Senate to support our highway workers by passing Senate Bill 479. Thanks for the opportunity.
Excuse me. Good afternoon, Mr. Chair and members of the Judicial Proceedings Committee. My name is Mike Higgins, and I'm the General Manager for Concrete General Inc. I'm here today to speak in favor of Senate Bill 479, the Maryland Road Workers Protection Act. We're a family-owned, Gaithersburg-based highway contractor working primarily for MDOT-SHA and MDTA, building and maintaining our roads here in Maryland with over 50 years in the business and currently over 300 employees. Last year on March 22nd, Concrete General lost 5 workers on I-695 from the crash. That changed our company, changed the victims' families forever. With me today is Kim Simmons, the widow of Stick Simmons and mother of MJ Simmons, 2 of those victims. Also here is Wanda Green, Stick's sister. Besides Stick and MJ, we lost Pancho and Carlos Escobar, 2 brothers, and Chichi Ruiz, another member of that crew. Sybil DiMaggio, KCI employee, was the 6th victim that day. Over 100 years of experience was lost in a matter of seconds on 695 on March 22nd. So Wednesday afternoon, around 1 o'clock, by a driver entering the work zone at a speed over 100 miles an hour. We desperately need to see safety changes made in Maryland work zones so this does not ever happen again. The construction work zone is the work office for our field folks. Every day our workers are putting their lives on the line when they go to work on our roadways here in Maryland. We all need to do our best to help our workers go home each night to their families. The changes outlined in SB 479 are a step in the right direction. I ask that you do not forget what happened on March 22nd, 2023, and help make our office, our work zones, safer. Please vote favorably on Senate Bill 479, and thank you for your time today.
Good afternoon to you all, and thank you for this opportunity. My name is Miranda Gross. I'm the dispatcher of Sunrise Safety Services. I've been with Sunrise for 15 years. The first 8 years were on the roadways. Sunrise Safety Services is a traffic control company located in Glen Burnie, Maryland. We fabricate signs, banners, car details, and so much more in our sign shop. We also install signs, tape, and crash cushions on the roadways, as well as provide lane closures, flagging operations, road closures, detours, and so much more. Most importantly, we are a family. We have 108 employees, I'm sorry. We have 108 employees, and I have a personal connection with them all. I love these men and women and their families, and I have to do everything in my power to keep them safe. We have our own safety committee and meet every week to find more ways to make us safer. On top of that, we meet with our MOT managers once a month and entire company once a month as well, in order to keep our road crews informed and engaged. I'm here today to speak in favor of Senate Bill 479, the Maryland Road Worker Protection Act. We desperately need to see safety changes made in Maryland's work zones. Every day, our workers put their lives on the line, and we need to ensure they go home each night to their families. I know that these changes are a step in the right direction. I appreciate Governor Moore and Lieutenant Governor Miller for all of their hard work for introducing this bill to protect Maryland's work zone employees. I would like to thank them, not just from myself, but from the entire construction community. So many have not had the pleasure to see and feel the love, energy, and concern that they have shown from the very beginning. On March 22nd, 2023, all of us in this field felt this tragedy. My phone immediately started blowing up with phone calls and text messages from our employees and contractors asking if we were okay and who was involved. A lot of us have worked with some of who lost their lives that day. We cried and mourned over this. We never want any family to go through what these families have gone through. Imagine going to work to provide for your family and not making it home, not because you did anything unsafe or wrong, but because others had no concept of their choices can do. Please help us make changes and a difference to keep our men and women safe. Thank you for your time today, and I ask that you vote please favorably and on Senate Bill 479. Have a wonderful day.
Afternoon. My name's Janet Gronke, and I am the president and CEO of Sunrise Safety Services. Sunrise is a traffic control company. We're located in Glen Burnie, Maryland, and we have been in business for 28 and a half years. We have 108 employees, and approximately 87 of them work on the road. Excuse me. Miranda? Yeah. They work on the road setting up lane closures, installing traffic signs, temporary pavement markings, crash cushions, and more. Today, I'm here to speak in favor of Senate Bill 479, the Maryland Road Worker Protection Act. I've had the opportunity to be a part of the Governor's Work Zone Safety Committee. We've discussed the things that we believe will help, and I appreciate the governor and the lieutenant governor for all their hard work and dedication for introducing this bill to protect Maryland work zone employees. We desperately need to see safety changes made in all of our work zones. Can you imagine doing your job every day with these kinds of hazards? Seeing someone you work with get injured or killed while just simply doing their job? Every day our workers put their lives on the line, and we need to ensure that they go home each and every day to their families and loved ones, and that they come back to their work family. I have been with Sunrise for 27 years, and I've seen my fair share of vehicles coming into our work zones and injuring our employees. So that's the reason I'm here today, to hopefully show you why it's so important that you vote in favor of this for Bill 479. Please remember, when you're driving, to travel through our work zones safely and spread the word to everyone you know, because it can save a life. I thank you for your time today. And again, ask that you please vote in favor of Senate Bill 479. I know that these changes are a step in the right direction. Thank you.
Thank you very much for your testimony. I'm going to give the members of the committee an opportunity to ask questions. Seeing none, thank you all very much for being here. With that, that will conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. And we have Mr. Giannetti. Welcome back to JPR.
Hello. Members of the committee, it's an honor to come back here into the committee on which I served years and years ago. Great to see Senator Charles. I see some great senators, Senator Muse from Prince George's County. I'm going to mention Prince George's County in this testimony. I am not here representing any organization. I'm actually here representing a concept, and that concept is institutional memory. And I want to fill this committee in on a little bit of the reasons why for the past 18 years, speed cameras have only been $40 maximum. That's when we first passed this bill. It was a Montgomery County bill back in 2005. I was sitting right in this seat. Senator Mooney was sitting over in that seat. We had to come up with a nice bipartisan way to be sure that the government never appears to have a conflict of interest between the interest of safety and the interest of raising money. So Senator Mooney and I came up with a list of amendments that we were able to pass, and $40 has been the amount that a speed camera can be. It's been there for 18 years. Now I see a real risk that that might not happen. It might not remain that way. So I've come here to say, listen, it's important that as a society, as a government, we never have the public wonder if the reason why the government is doing something is to make me safe or is it to raise money. All right, so what we did was we put it down at $40 to make sure there was no argument that this was there to raise money. It's not going to make a lot of money for any group, but you can still see the proliferation. Imagine if the amount was $100 as the original bill or $290. You'd see these speed cameras everywhere. You'd see municipalities in Prince George's County going, let's set up a safety zone so we can make $290 every ticket. We don't want to be there as a society. You have to remove that from this bill and try to, if you can, to make sure that the reason behind the bill is for safety. And I think there's some amendments you can make. I only have this amount of time, so I ask that you amend it dramatically and don't pass it the way it is now. Thank you. I'm very good, my good friend. How are you? I love that jacket.
Thank you. Thank you. A couple of questions, and I understand because we grappled with this a long time. Number one, it appears to me that even at $40, it no longer has any effect because it's gotten worse.
Right.
People either know where they are and they slow down and they keep going. I live off of 210, and 210, according to AAA, is the sixth worst traffic traveled road in the nation.
I believe it.
That's from AAA. I'm grappling with, I'm not sure if somewhere between the fines, because I'm concerned about fines in poor communities, et cetera, et cetera. But on the other hand, I'm really concerned about all of the deaths I've had and what my people are saying in my district. They've changed their tune regarding the speed cameras. I have another building where they're saying, put more cameras here because we are at risk. And so I guess my question is it a deterrent? And if so, and it's not working, what should we do? Because people have absolutely gone crazy when it comes down to their driving habits. And it's no longer, we had seatbelts. Nobody wanted to wear seatbelts. Well, now everyone just automatically puts on a seatbelt when they get in the car. That has not had that effect. What do you suggest that we do in the meantime that could have some effect? Because if it's not having an effect, then it is just that, a money-raising tool.
Right.
But if it's something that can be a deterrent and change behavior, and because it's $40, it's not changing behavior, what do you suggest we do?
Well, thank you, Senator, for the question and the opportunity to expand a little bit. I think that the desire behind this bill is a good one. I think we need to protect those people on the side of the road. I worry about them all the time. I worry about a police officer, Senator Fulton, a police officer that pulls over a speeding person. I'm really concerned about this. There's a lot of ways that the governor's committee identified as improving the speed zones, not just speeding, but the speed zones. I know that 210 was recently added into the legislation that you're allowed to now put one down on 210. I think that just added. I don't know if it's in effect yet, but it's in effect soon.
In effect, we're now putting more.
Yes, okay. So, and I know that the speed zone on the JFX worked also. A concern that I have in this bill is something that I think Senator Fulton or Senator James brought up, was the concern that this is actually not going to the speeder. This is going to the owner of the car. All right. So I worry that maybe the owner of the car, if it's not the person who's driving, that's maybe they don't worry about speed zones because it's not going to be them that gets the ticket. you know, maybe that's one of the issues that we have. So maybe addressing that issue, that it's actually somehow the driver. I love the fact that when you don't have an automated speed camera, that you have a police officer to determine whether or not there was a good reason to be speeding. And you and I both know there probably, we could list on one hand easily reasons why you might want to speed, that it's in the public interest to speed, getting a woman to a hospital who's pregnant, you know, who's going to have a child, an injury to a child perhaps. So having a police officer give the ticket, he can decide whether or not using his own, you know, opinion. So I think that somebody also mentioned that the people who are the worst speeders, Senator, you know, there might be a sliding scale, that if we are going to have these things, the people who are going over 30 miles an hour faster than in the speed zone, maybe that should be a bigger ticket. All right. But I think we're really on a slippery scale by allowing the proliferation of these, especially into municipalities, because two senators, Prince George's County, I came from Prince George's. Prince George's County has 47 municipalities. You're going to tell me that they're going to operate, you're going to tell Berwyn Heights, where I came from, that they're going to set up a work zone on Pontiac Street, which is my old street. And it's going to be to repave something, but they're going to put a speed camera right there. And I don't know how long that's going to be there and who's going to monitor how long that work zone is going to be there. And I think when you're trying to allow the individual municipalities to raise money by these tickets, that maybe safety's taking a back seat. And I don't think it's wrong to be asking for money, but the money shouldn't be at the expense. You should never have a government saying, oh boy, we're benefiting from people breaking the law. Look at this, we're raising money because people are breaking the law. We hope more speeders come down because we need to make that budget. We need to balance our budget. Let's hope we have more speeders in the work zone.
People can say the same thing about police officers when they say they have to make, you know, reach a quota or whatever, whether it's true or not. They already say the same thing. It's about money. So what's different?
Well, and I think the thing is that, and correct me if I'm wrong, Senator, I think we, at least for the state police, which is this legislature, I think we outlawed is the wrong word. We've put something in the statute that says they're not allowed to have those quotas. And that exactly shows you how negative their opinion is of the populace about the government. They think they're out there trying to raise money. Right? We don't want to give them that reason. And here we have the governor of their state saying, we need to raise money. Let's raise the ticket. Let's raise the cost of tickets.
So this is in the same posture of current law. You can't make it a quota. I know what people will think, but they think a lot of what we do now. We have to do what is best. And so it's the same. It's even. It's not no quota system for the cameras, no quota system for police who are giving out tickets. I'm trying to just see where the difference is.
Well, the difference is because when you have a police officer, if that police officer has a goal that he has to make, and that when you generate that ticket for that, the police department, the Berwyn Heights Police Department, the District Heights, or the, you know, Seat Pleasant Police Department, you would never want that money to go into a general fund or into any, never want, even in the current system, the municipality or the state or whomever, the state highway administration, to benefit from someone breaking the law. And so if it does that, then this body should step in and make sure that it doesn't look that way. And this bill, the way it's currently written, and I think you can improve it, looks that way now.
I got you. Okay, thank you. Thank you very much.
Sure.
Senator Folden.
Thank you, Chair. Thank you, sir, for coming out. I appreciate your enthusiasm and understanding that the complexity of the bill, we're trying to pass something that's meaningful, but we want it to have the meaning of the intended purpose, which is work zone safety.
Right.
So in that spirited, and by the way, I guess you didn't like my jacket.
I thought yours was much better than Senator Muse's.
Okay, all right. See, that's what I was, thank you.
Yours is the best.
Yeah, thank you. So you bring up a very valid point, and this is one of the concerns I have, because I'm in a district, unfortunately, that several of the victims of this horrific crash last year live. And when you have that type of personal impact to your community, it requires change, right? And so we have to move forward with the idea of the proper lens of the change that we're trying to accomplish. And, you know, it's no different than one of the things, it's funny you bring up, like Montgomery County was the first one to do it. There's a continuous battle, it seems like at times, that, you know, Montgomery County may want to be the first one to bring up a new bill or lowering speed limits below what's a enforceable amount in the state. They wanted to be able to do that years ago, and they couldn't do it, so they got upset. So they wanted to just do it just for Montgomery County, so everywhere else is stated. So now we've gotten to the point where, again, because of the governmental trust issue, that we're allowed to conduct a speed study to to adjust the speed limit down below what is normally your associated speeds. Like in residential areas, it's 25 miles per hour. In business districts, it's 30 miles an hour. Well, now if they perform a speed study, regardless of the results, because it's a speed area or a zone that is not of a high enough speed, right? Regardless of the results, which they don't have to publish either, they can then, as long as they conduct it, move the speed limit down. And in those areas, we're seeing a high concentration of cameras. That's concerning to me, right? Because that gives this credence to what you're saying, is that it's somehow, you know, this money grab. I don't feel that the design of this is to be a money grab. Right. I have concerns about the height of the sudden shift of $250 without a scale, which is what you already alluded to. So, you know, if we're talking about speed or safety, though, wouldn't it be something, and maybe, you know, I'm asking you to comment, wouldn't it be something to look at maybe restricting, almost like a funnel, the number of lanes, so that the lane nearest the associated workers, or, you know, where they are, is no longer in operation? You just create that squeeze, which in and of itself creates a slowing effect in that area. Right. That's one solution. And it doesn't put our workers right on the buffer of vehicles that at 50 miles an hour are going 74 feet per second. Right. So that's one. The other one is, obviously, you know, and they do this in some areas, when you restrict the width of the lanes. By nature of humans, we see that as constrictive, even though there may be nothing on either side. If we see those lanes, we want to stay inside those lanes. So the natural human reaction is to slow down, because you don't want your car going off onto the painted lanes. That's another thing. I mean, do you agree with what
I like where you're going, Senator, and I endorse those two amendments to this. You know, I think that makes a lot of sense. I think the bill has to be crafted. Well, first of all, you know, God bless the governor and the lieutenant governor, because they're trying to solve a problem. Sure. And they were given a committee that I know that one of your senators from this committee, Senator Kelly, was sitting on that, and it was great. The thing is, you look at the roster of who's on that committee, and it's all workers, and it's all people who are on the road. It's not people who are making legislative policy. And one of their recommendations, and they probably had 30 recommendations, I printed it out and read it. One of them was raise more money through speed enforcement. And that's what turned into this bill. And that's the concerns I have with not the raising of the money, but that a governor comes out trying to solve a problem now. Right. A governor comes out and says, this is how we're going to raise some more money for this problem. Okay, that's okay. Now, as far as what you said, you know, when I talked to Senator James before this, we started coming up, you know, in our head about the different amendments that could make this bill better. And I liked one of the statements that you said, that you didn't use as asked me to react to, but was making sure that the workers, like in the middle of the night, is a different safety hazard to workers than when the workers are present. And that you could define in the bill an active work zone, and that work zone has to reach a certain capacity, so that a municipality that is using it not for safety but to raise funds wouldn't meet that standard. In other words, there has to be at least a worker there present for that camera to be working. We want to keep them safe. But at the other time, also, I think you want to be sure, and nobody in this committee has talked about it when we're talking about this bill, it doesn't stop at $290. I mean, this bill has other provisions in other sections of the law where it could be over $1,000, you know, for a ticket, you know, after a certain amount of priors. Now, and again, it's not the person who's driving, it's the owner, that poor owner who has kids with it could be a disaster. So all I'm trying to do is say, if the committee wants to live up to its legislative purpose of making sure that people stay safe, they can do it without looking at it, allowing municipalities to raise money this way. I think you can make them safe.
I think that, the reason I brought up about the buffer, the additional lane,
Yeah.
should those be available, because your higher roadways are gonna have more lanes, right? So if you had the adjacent lane, we did a similar measure to protect the tow truck drivers and law enforcement, the move over law,
right?
Which says when you need to move over to create that buffer, because we were having people being struck on the shoulders of the road. So it just seems like it would maybe fall into some of that as well. And then the other point I just wanted to, when you brought up about someone brought up, I forget who it was, so I apologize, about school zones. And it made me think, all right, I'm going to pull this up. Well, I pulled it up I'm looking at the Maryland fine schedule right now. And if you're in a posted school zone, exceeding the speed limit by 10 to 19 is $140. So, are we saying that our children are worse? I just, if we're talking about safety, there's got to be parity and consistency that doesn't appear that we're, like you're saying.
I mean, putting up cameras to raise money.
They're important. Yeah. And it's too important of an issue to have that be the potential lens that it's viewed through. Agree. I agree.
I agree wholeheartedly. Okay. And Senator, I think somehow in the wording of this, that you could certainly say that that a speed camera that hopefully you would put it back down to 40. If you made this bill that the speed cameras that were automated are still down to 40, but allow the police officer to give to up to 290 or up to 1,000, you allow the officers who have discretion to
and
do
that's
it.
already in the law. Right. That is in the law as far as work zones for law enforcement. So,
but not allow these cameras to do that. I think you could easily say that if the speeding takes place in the lane adjacent to the work zone, that's when it would be effective.
It's a good discussion. So I appreciate your time.
Thank you very much,
Senator,
Senator, for the question. Thank you.
All right, seeing no more questions, that will end our hearing on Senate Bill 479. Next, we're going to have Senate Bill 740. Senator Guile.
Okay. Oh, hey, how are you? Good. Have a seat. Have a seat. All right. Good afternoon, Mr. Vice Chair, members of the committee. For the record, Senator Don Guile, District 33. Senate Bill 740 would establish the needed infrastructure to enforce existing laws that bar individuals who have been convicted of boating under the influence from operating a vessel. The bill also increases the maximum number of years these convicted individuals may be barred from operating vessels. Sadly, like many bills before this committee, the need for SB 740 comes about from a tragedy. In June 2022, Crofton resident Nick Barton was killed in a boating accident in which the operator of the vessel was under the influence of alcohol and cannabis. His fiercely loving mother, here with me, as well as his father, have spent the last 20 months raising money for various causes and working with my office to change the law in Nick's honor. It is illegal in the state of Maryland to operate a vessel while under the influence of drugs or alcohol, just as it is for any other vehicle. And while the limits and penalties are technically the same, the administrative process is vastly different. First, the state of Maryland issues driver's license that can be suspended and revoked in an administrative process that operates separate and in parallel to a criminal procedure for conviction of driving under the influence. While Maryland does require boaters to obtain and carry a Maryland Safe Boating Certificate, which can be obtained after completing online courses, among other sources, it does not issue boating licenses. The Maryland Safe Boating Certificate that boaters are required to carry when operating a vessel is not registered with the state. In other words, the state does not have a list of certificate holders. Therefore, their certificate cannot be suspended or revoked. However, when a boater is barred from operating a vessel during a given time, such as, for example, a court can order that a individual be barred from operating a vessel, The judiciary has a record of the order, meaning that it is kept in the clerk of courts. However, that's where it stays. It does not currently send this order to the Natural Resource Police within the Department of Natural Resources, nor does DNR have a process in place to store this information. Consequently, an order barring an individual from operating a vessel does not prevent that individual from in the future operating the vessel because there's no enforcement mechanism. To address these issues, my office worked in partnership with the Barton family, as well as with DNR over the interim to draft SB 740, which would require DNR to create and maintain a database for the barred operators and require the judiciary to send names of the barred operators to DNR. The database shall be operational by no later than October 1st, 2025. This bill would also increase the maximum time someone convicted of a BUI may be barred from operating a vessel from 1 to 2 years. In a case where a death is a result of the BUI, the maximum period would be 5 years. I have submitted a clarifying amendment with my testimony that addresses some concerns expressed by DNR just on the fines and prison guidelines for individuals in violation of suspension of their voting privileges. And for these reasons, I respectfully request a favorable report on Senate Bill 740. Thank you, Mr. Vice Chair.
Good afternoon, committee. My name is Marie Barton. I am Nicholas Barton's mother. I wanted you to see a picture of what this bill is named after. Nick's Law. That infectious smile goes a long way. This means a lot to us. We never knew there were no laws for boating, for BUI. This was a rude awakening for our family. To not have a database, not to have anything that DNR can revert to, especially for a boating state as Maryland is unfathomable. I cannot believe that there is nothing in place for this, especially for a BUI. If this bill can save one life and not have to have a family go through what we're going through, then I know that I've done my job. I know that Nick has done his job. This committee has done their job. We need to get stricter laws in place for boating. There aren't any in place. Other states have strict laws and their death rate and accidents are not as high as Maryland in my finding. I could be wrong, but I've done a lot of research in this. I've had a lot of time, sleepless nights, looking over what can be done so this won't happen to anybody else. I would request that please in favor of this bill. This means a lot, not only to my family, but I think to other boaters that have gone through this tragedy. And if you can just look at this smile and look what this bill is named after, this is my mission as a parent. This is, as they call, like the mama bear with her bear claws out. I won't stop fighting for stricter laws for boating, especially in my son's name, Nicholas Barton. Thank you.
Hi, good afternoon. I'm Ed Barton, Nick's father. I'm going to read what I've written. As Nick's father, I'm advocating for the passage of the bill HB 740, and known as Nick's Law. It is a crucial step towards ensuring justice and accountability for the tragic loss of Nick. Nick's ultimately passing as a passenger on a boat by an individual under the influence of drugs and alcohol just highlights the urgent need for stricter penalties and enforcement of boating laws. Nick's Law represents the vital opportunity to strengthen boating regulations and improve stiffer penalties for those who endanger the lives of others through reckless behavior on the water. By advocating for this bill, we are not only seeking justice for Nick, but also working towards preventing similar tragedies from others in the future. Through sharing Nick's story, advocating for the passage of Nick's law can arise awareness about the dangers of boating under the influence and on the water. Let us unite in our efforts to support the bill and advocate for the implementation of stricter penalties to deter irresponsible and dangerous behavior while boating together. And we can honor Nick in memory of Nick for safer boating laws. Thank you.
I feel like I've been before you so many times this year and I've never testified before this year. I'm Carolyn Grammis, Assistant State's Attorney here in Anne Arundel County. It isn't until these tragedies occur that you don't realize what's missing and what we can and cannot do. And one of those things that we cannot do is that when someone is pulled over while operating a vessel under the influence of alcohol, we can't check. I can't look and see, are you barred from operating a vessel? The family here sits here for the Bartons, and the driver operator of the vessel that killed their son is barred from operating a vessel for 5 years. The way that will occur during probation, the only way that would occur is if the officers who are involved happen to be around, hear the name over the radio, but there's no other way for them to know that he's not able. Maybe someone gets it somewhere secondhand and then we find out about it and we try to figure out how to do a violation of probation, but that's where we miss the mark. And that's why we're here. You heard from the Slatterleys recently, another boat incident. Again, that operator also barred from operating a vessel. Again, same situation. How do we monitor that? How do we keep up with that without having a database? MVA, we can check very easily. But on the water, one of the things you hear most often on the water is everyone drinks on the water, which I think is the most ludicrous, outrageous thing, that an operator of a vessel, that everyone thinks it's okay to operate a vessel while drinking, but not while doing a vehicle. What is the difference? This is a safety issue. This is an issue that needs to be closed, this loophole, so that we can watch, monitor, that people who are not able to operate a vessel, that we're able to check that, and officers have the tools in order to stop people from doing this. I urge your favorable report on this bill.
Mr. Vice Chair, members of the Judicial Proceedings Committee, my name is Dylan Baylor, and I'm testifying on behalf of the Maryland Department of Natural Resources. Firstly, I'd like to thank Senator Guile and Nick's family for being here today and for working on this really important issue. As of today, as you heard, the department does not have the system in place to be able to effectively monitor and gather the information when we are on the water of those that have had their privilege of boating revoked because of a BUI. This bill does just that and will provide the department with the necessary information and require the department to create said system. So that way, when we are on the waterways, we will have that ability to look on our computers on the water to see if said person is not supposed to be boating based on a conviction. I did want to touch on the amendments that we are offering to the committee in our testimony. We see it as really important to provide penalties in this situation to ensure that those that have been have had that privilege revoked, that if they are caught doing so in our natural resource police in the newly created system, find that person was ineligible to be boating, that there are penalties in place and a legal recourse for them to face penalties. Again, this is a critically important bill for the department as we continue to expand and usher in our work on making sure that all boaters and all Marylanders are safe on our waterways. And I'd like to thank the family again for their leadership in working on this. And with that, we would request a favorable report with amendments.
I'd like to add our thanks as a committee and our condolences to you and your family. So thank you. It's very difficult to come here and testify. Questions for the sponsor or for the committee? All right, seeing no questions, we'll move on to the rest of our proponents. Patrick Gilbert, Ian Goldstein. And I think that's it.
Good afternoon, Mr. Vice Chair, distinguished members of the committee. My name is Patrick Gilbert. I'm a senior assistant state's attorney in Wycomico County, and I'm here this afternoon on behalf of the Maryland State's Attorneys Association to urge your favorable report on Nick's Law. It's a bill that takes boating while under the influence seriously, and it's an important step in making sure that our laws do that as well. I want to get right into the weeds on probation conditions, because I think that's really going to be important. It's an important context for this committee to consider when weighing the wisdom of this bill. Courts enjoy broad discretion, generally speaking, to impose sentences that fit the crime for which someone's been committed and to impose conditions that fit that crime as well. In the context of automobiles, for a very long time, there was a case that basically said courts can't restrict individuals who have been convicted of driving while under the influence from driving a car. And that stemmed from a separation of powers idea, from this concept that the General Assembly had established this really extensive regulatory framework and delegated that authority to the Motor Vehicle Administration. And so it wasn't appropriate for the judiciary to be weighing in on who could and couldn't drive. 2015 rolls around, the Supreme Court of Maryland changes course and says, no, of course, it's an inherent power of the judiciary to control the conduct of individuals who've been convicted of crimes. So now courts, when they place individuals on probation for alcohol-related driving offenses, can say, no, you are not allowed to drive a car. Even if the MVA gives you your license back, you're not allowed to drive your car for 6 months, for a year, for the duration of probation. I bring this up because I'm skeptical as to whether a court could do that currently with regard to someone who's been convicted of boating while under the influence. And that's a function of subsection E3, which is expanded by this bill. This bill authorizes courts in a very narrow set of circumstances. So there's really 4 modalities of boating while under the influence. This really applies to only subsection A, what we would call driving under the influence or boating under the influence. I think it would be wise for this committee to consider expanding this to all modalities of driving while under the influence or boating while under the influence, to give courts the authority to tell people who've been convicted of boating while under the influence, no, you can't operate a boat while you're on probation. I yield to the committee's questions and thank you for your time.
Thank you. Let's take our virtual testimony and then see if anyone has any questions. Mr. Goldstein.
Thanks so much, Mr. Vice Chairman and members of the committee, for allowing me to testify in support of SB 740. My name is Ian Goldstein. I'm the Vice President of Government Affairs with Mothers Against Drunk Driving. MAD represents the millions of victims and survivors of drunk and impaired driving crashes. MAD's mission is a future with no more victims. MAD thanks Senator Giles for authoring and introducing this life-saving legislation. And thank you to the Barton family for their courageous testimony today. And I'm very sorry for your loss. MAD urges the Maryland legislature to pass SB 740, which would make improvements to Nick's Law by strengthening penalties for operating a vessel under the influence of alcohol or other impairing substances. In 2022, Maryland had 14 fatal boating crashes, and alcohol was the leading cause of these crashes. According to the U.S. Coast Guard, boaters are 10 times more likely to be in a fatal boating crash with a blood alcohol content of 0.1. SB 740 not only strengthens the amount of time an offender is prohibited from operating a vessel on the waters, but it also creates a database with the Natural Resources Police Force accessible to a Natural Resources Police officer. The creation of a database will ensure that BUI offenders will not continue their behavior on Maryland's waterways, creating danger for operators of other vessels. Maryland's current BUI laws can deter someone from operating a vessel under the influence of drugs and alcohol. However, strengthening the current law with longer suspensions for those who break the law and operating a database will make offenders think twice before operating a vessel while impaired. The goal of SB 740 is to deter illegal behavior on our waterways. Mr. Chairman, Mr. Vice Chairman, and members of the committee, please pass SB 740 favorably out of committee to ensure safety on our waterways for everyone. Thank you very much.
Thank you so much. Question for the State's Attorneys Association or our representative from MAD? Senator Sidner.
Is it Mr. Gilbert?
Yes.
Would you mind coming?
Oh, yes, I'm sorry.
And thank you very much for your testimony. You all are testifying in favor of creating a database, and this is for the Department of Natural Resources. Are you aware that your association is in opposition of ensuring that state's attorneys have a database to keep information to do similar kinds of things?
So I think your question relates to the
Senate Bill 617.
Yes, the bill that has two parts, the task force and the grant funding bill.
Mhm.
What I would suggest to you, Senator, is that this database fundamentally differs in purpose from the database at issue.
It's all about public safety. I'm just feeling that's a little bit hypocritical.
And that's a point well taken, Senator.
Yeah, I just feel it's a little hypocritical that you all don't want the type of information for your office, but you're all right as long as another department is keeping that kind of information.
So this database is something akin to what the Motor Vehicle Administration has for licensees. So it would, in a driving context, it would be like if a police officer pulls someone over and there was just no way to check if this person was licensed to drive or suspended or had ever been licensed to drive. And this establishes a database for natural resources police officers to be able to determine whether a court has ordered someone not to operate a boat during their period of probation.
Do you all expect to have access to this database?
Well, I think that's an important question. It might be right for this committee's consideration is to delineate who would have access to this. There's no particular reason why our office would need access to the database generated by the Department of Natural Resources because we have access to court records.
So
and
why,
this would
so
all
why
be
are you all testifying in favor of this if you have no role in this? I'm trying to understand.
So we are testifying in support of this because this builds out an important enforcement mechanism that ensures that when courts order people not to drive boats as condition of their probation, that we are able to adequately, that our partners in law enforcement are able to adequately interdict that conduct and make sure it doesn't happen.
And ensuring that state's attorneys have grant funds available to ensure that you all have case management systems isn't a public safety issue?
So I'm happy to dialogue about the case management software because I think it's a really interesting issue. And I think the nature of the State's Attorneys Association's objections to that particular bill aren't necessarily on the merits of what that bill does. Because I think if you ask, and I'll preface my comments with this, no one has elected me. No one knows who I am. I work as a senior assistant state's attorney in
I'll leave you
Wycomico.
alone,
I've
then.
never had to
I'll
run.
leave you
I
alone.
don't have a constituency I represent.
No problem.
That being said, I would be surprised if any state's attorney would disagree with the idea that more information makes them better at their job in terms of understanding the situation on the ground, in terms of understanding how they want to shape policy for their community. The challenge is, I mean, if we could wave a wand and that data set would appear into existence 24 out of 24. I can't guarantee it because I haven't talked to them all, but I would bet that 24 out of 24 would be like, absolutely, because that data is invaluable. You can say, look, we're seeing far too many of these cases being handled in a way that's inconsistent with what I, as the elected representative to administer the criminal law for my community, think would be appropriate.
I appreciate it, Mr. Gilbert. You're fine.
Okay, all right.
I appreciate it. Thank
All
you.
right. Thank you, Senator.
All right, any further questions? All right, thank you so much. Thank you, Senator Guile, for bringing the bill. Thank you to the family for coming this afternoon. So we've had to move some folks around for the next bill. I think Senator Charles was up next, but then Senator Kelly returned from finance. Is there someone who'd like to go first? Senator Kelly. I have 3:15.
Need to run across the street. So thank you. And I owe you, Senator Charles, a favor. And I can bring my panel in. Thank you. Come on and sit down and I'll get started because I know we're in a bit of a hurry. So I'll go ahead and start as the panel gets settled. This is Senate Bill 315. You all have an article on your desks that's from Maryland Matters. I put on your desk so that you had it today, that you should refer to, give some really personal details. We have some people who had testified today about this situation. So Senate Bill 315 is the Sarah Debink Langenkamp Memorial Act. This is a sad story, and you all know that I've been sick and sniffling. Please know I'm not weeping through this testimony, although my heart is. So Sarah Langenkamp was a constituent and a devoted mother, wife, and U.S. diplomat. On August 25th, 2022, Sarah was biking home in Bethesda using a designated bike lane when she was struck and killed by a driver operating a flatbed truck. Sarah's husband, 2 young sons, and family have been left to grieve this senseless loss. In just 2022, there were 606 total crashes in Maryland involving cyclists, and 11 of those were fatal. Our cyclists deserve to make it home to their families safely. Sarah's death was preventable, like many others, including the death of Nathan Krasnopler. I hope I said that right. I hope I did. Good, it's close. That was in Baltimore in 2010, and his mother is here with us as well. When losses like these happen, the families are left feeling a lack of justice. The driver who hit Sarah was given the maximum penalty under the law for causing the death of a vulnerable individual. That was $2,000 and 150 hours of community service for causing her death. And of course, a wife and mother were gone forever. SB 315 increases the fine for a vehicle failing to yield to a cyclist in a bike lane and causing a crash, up to $2,000 and or 2 months in jail. These penalties have precedent in Transportation Title 21. What it does is basically it takes the existing $2,000 fine for causing a serious injury or death to a cyclist or pedestrian, which is from Transportation 21-901.3, and adds to that the existing penalty of up to 2 months in jail for a driver who fails to stop a pedestrian in a crosswalk, for a pedestrian in a crosswalk. So the 2-month in jail penalty already exists. We would want to apply that for folks who are in this situation. The seriousness of failing to yield to individuals who are using designated bike lanes or crosswalks can cause serious injury or death. The increased fine amount for this violation is a step to encouraging Marylanders to drive vigilantly and be aware of cyclists using bike lanes and crosswalks. This is a modest increase. This is a piece of legislation I worked with Delegate Love, as well as Chair Corman, because this is an incident that occurred in our district. And we know our community was really, really shaken by it. We did not want to come in with, exorbitant penalties, but we wanted to make a difference. So with that, I have just a small panel here. We have Dan Langenkamp, who has become quite an advocate and is the husband of Sarah Langenkamp, as well as Kyle O'Grady from the state's attorney's, Montgomery County State's Attorney's Office, and Susan Cohen, who is also an advocate. And as I mentioned, her son Nathan was killed in Baltimore in a similar accident. So we will hear from them, and I urge a favorable report. Thank you so much.
Thank you, Senator Kelly. Chairman Smith, Vice Chair Waldstreicher, and Senators, thank you for your attention today. You may remember Sarah's story. It's 18 months since Sarah was killed. And just last fall, the driver was sentenced. And when he was sentenced and given this fine and a few hours of community service, the judge literally apologized to us, saying there was nothing more that the law could do to hold him accountable. And we left feeling utterly destroyed because the law just has a gap. Well, it was after that that I contacted the state attorney's office, John McCarthy in Montgomery County, and he said to me, actually, we agree with you. Something needs to be done about this. And what we could do is just take the law that exists for crosswalks and you could apply it to bike lanes in this state. It would be very easy, very elegant fix. We agree that there are certain spaces that need protection, crosswalks need protection, and bike lanes. Actually, we built them all over the state. They need protection too, and we just haven't thought to actually do this for them. And I said, that sounds great. He said the fine, the fine and the punishment is not very high. And we agreed. I looked it up later. As you'll see in the article that I wrote today for Maryland Matters, in Maryland for littering, you can be jailed for up to 5 years and fined $30,000. Now, what are we saying about life when you're just given a $2,000 fine and a few hours of serving cookies at your church on Sundays? And a 6-month suspension of a license. The driver actually will be driving next month, and he's probably done with his church service. So I'm livid about this gap. I just don't understand it. So I would ask you to take a look at the law. I would plead with you to say, let's do something about this. I mean, there's a real need also across the country. And that need is that there are more than 40,000 people killed on our roads because distracted drivers and because of heavier and faster cars. So we need to decrease this number. And so therefore, I urge you to support the bill. Thank you very much.
Good afternoon, Chair Smith and Vice Chair Waldstreicher and committee members. I've been before this committee many, many times in the past as an advocate for older driver safety, something that I failed at miserably, never got anything passed in 5 years. So this is the guy that I lost on February 26, 2011, when he was in a crash with an older adult driver. He was 20 years old, a Hopkins student. He later died after the February crash in August 2011. The older driver entered his bike lane on a Saturday morning, and he ended up trapped under her car, 2 collapsed lungs. She sat on a wall and did nothing after the crash. Enough minutes passed that his brain cells were gone, and he continued to live in a vegetative state. So she could have done some things to save him, but unfortunately that didn't happen. And she violated the 3-foot law, staying 3 feet away from a bike. And she was charged with negligent driving without injury. Wrong box was checked. Fine, $200. Referral to the medical advisory board at MVA, a top-notch service at MVA. No, that didn't happen. So that was 2011. Thank God we've got the vulnerable road user law now, and I'm very happy about that, but it's still not enough because our culture of cars in this society means that people don't really take bikes or bike lanes seriously, and drivers often don't notice them. Sometimes drivers are hostile towards bicyclists and others on the roadway, but those road rage are for everyone. So I would like to urge you to give a favorable report to 315. This is Sarah Langenkamp's Memorial Act. I hope it's passed for the sake of Sarah's life as well as my son Nathan's, because we need to do more to communicate to the road users out there, the ones in the metal and steel vehicles, that in fact other lives are important on our roadways. Please give it a favorable report. Thank you.
Thank you. Good afternoon, Chair Smith, Vice Chair Waldstreicher, and committee members. My name is Nigel Samru. I'm a member of the Maryland Bicycle and Pedestrian Advisory Committee. I sit on the board of Bike Maryland, and I'm also the chair of the Advocacy Committee of the Baltimore Bicycling Club. As some of you know, I've previously appeared before you as the face of the victim to testify in support of the VRU legislation. I'm here today to testify before you in support of SB 315, the Sarah Debink Langenkamp Memorial Act. As a victim who has twice survived crashes, one in 2017, which some of you on this committee are aware of, and in 2020, here in Anne Arundel County when 6 friends and I were hit by a driver, resulting in my dear friend being killed instantly. In 2022, 11 bicyclists were killed, and in 2023, that number has increased to 15. In 2023, 30% of Maryland's roadway deaths were vulnerable road users, and those numbers aren't improving. Bike lanes represent for bicyclists who are vulnerable road users a protected space where we should be able to ride our bikes with some degree of safety. When a driver does not exercise caution when bicyclists are using a bike lane, the result can be deadly, as we have seen in the case of Sarah Langenkamp, wife and mother of 2 sons and a U.S. diplomat, and Nathan Krasnopoler, a 20-year-old student at Johns Hopkins. Penalties aren't the only answer, nor are they on their own sufficient, but they can serve as a deterrent and a motivator for drivers to exercise greater caution and vigilance. SB 315 seeks to accomplish that by increasing penalties for those drivers that fail to exercise due caution and cause a crash that injures or even kills a person on a bicycle. A person on a bicycle that was legally operating in what should have been a protected space. Bike lanes are meant to be a place on the roads where we as bicyclists, as people, should expect a greater level of vigilance and caution on the part of drivers. SB 315 is a step in the right direction, and I urge a favorable voting committee and on the floor. Thank you very much for your time.
Good afternoon, Chair Smith, members of the committee. My name is Kyle O'Grady. I appear in support of this bill on behalf of State's Attorney John McCarthy and on behalf of the Montgomery County State's Attorney's Office, where I serve as a prosecutor in the Felony Trial Division and am the acting supervisor of the Traffic Fatality Unit. Now, Section 21-1209 of the Transportation Article exists to protect operators of bicycles by establishing the responsibility of drivers of motor vehicles. And these responsibilities are common sense. It's exercise due care to avoid striking cyclists, pass at a safe distance, don't throw things at them. And most importantly, for today's purposes, it's yielding the right of way to a person lawfully riding a bicycle in a designated bike lane or shoulder. Now, at present, any violation of one of these provisions is a payable citation, even if it contributes to an accident and even if that accident causes a death. This bill does not change the responsibilities of drivers or cyclists. Their respective obligations to follow the rules of the road remain the same. What this bill does is add an incarcerable penalty for when a violation of subsection D contributes to an accident. These are circumstances in which the cyclist is not in a travel lane sharing space with a vehicle, but rather in a designated bike lane or on the shoulder. It's using a separate portion of the roadway, a place where they should have the greatest level of protection under the law. This bill is consistent with our state's pattern of expanding protections to other vulnerable users of the roadway, as we've done with pedestrians, with wheelchair users, and with play vehicles. And the proposed penalty here is identical to the penalty provisions in those other statutes. Moreover, by adding this penalty provision, we provide judges more discretion to appropriately differentiate more serious cases. For instance, cases involving fatalities or cases involving subsequent offenders. And a violation that contributes to an accident becomes a must-appear citation. That extends the respect and recognition to injured victims, and when a fatality occurs, their next of kin. It gives victims their day in court. On behalf of the State's Attorney's Office, we urge a favorable report on Senate Bill 315. Thank you.
Thank you all very much. And Daniel and Susan, thank you in particular for your testimony. I know that you've been here several years, and so it's good to see you, but thank you for your continued advocacy. We'll now switch on for questions from the committee. Senator West has a question.
I did. Thank you, Mr. Chair. I guess for the committee sponsor. So let me tell you a story. Some years ago, my wife and I visited Amsterdam for the first time. We'd never been there before. And we were about to cross the street. And I looked both ways for the cars, and there was no cars coming either way. So I stepped out to cross the street, and I almost got mowed down by a bicycle. And we both would have been injured seriously. And I didn't know how prevalent bike riding was in Amsterdam. It's very prevalent in Amsterdam. And the bike riders are traveling at very high rates of speed. So even if I had seen the bicycler, I would not have assessed how fast he was traveling and realized what kind of danger I was in before stepping out off of the sidewalk into the street, across the street. And from that, I concluded that bikers can travel very quickly. So if I'm in a car here in the States, after this bill gets passed, and let me note that I'm talking about existing language in the law. I have no problems with what you're doing with this language.
I love that about you, Senator West. Okay,
So
let's go.
This is what the law says right now, but I'm looking at it carefully for the first time. If I'm about to turn right, I can see a car in the right lane, and I would, put my right turn blinker on and go over into the right lane and then make a right turn at that intersection. But if I'm turning to turn an intersection and there's a bike lane there, and the biker's way back in the bike lane, traveling at a fast rate of speed, in my rear view mirror, I'm guessing I'm probably not going to see that biker unless I'm really, really attentive if he's far down the road, because he can be traveling very fast and we could have a collision. I'm looking at the existing language, which says you can't turn if the driver of the vehicle, wait a minute, let me get it. So you're right away told the person's law. It just says you should yield right away to a person who's lawfully riding a bicycle. So does the law require me to look way back and make an assessment of how fast the bicycle is traveling before turning right across the bike lane? Is that the way the law reads right now? And so to bring it into this statute, should I really be penalized by up to $2,000 fine if I were to turn and a bicycler who's traveling really quickly hits my car and gets injured? I wouldn't get injured. The car would get dented, but the bicycler could suffer serious injuries if that occurs.
So I do think I understand your question, and it's sort of in two parts, and I'm going to answer the second part, and I'm going to defer to Mr. O'Grady on the first part, if that's okay. I see a nodding because, like you, this is a new section of statute for me, and it's had me thinking a lot. In my community, we have an increasing number of cyclists, and the answer to the second part of your question, and I want to acknowledge and appreciate that you said you don't have a problem with what we're trying to do with this bill. I just want to take the opportunity to bring home that this, the loss of Mrs. Langenkamp was obviously very personal for his family, but also had a really devastating impact community-wide. People don't feel as safe as they once did. And so I think that there's real meaning to passing this legislation and making this penalty a little bit more substantive. On the technical question of how roadways work, I'm going to pass it off to Mr. O'Grady because he has a lot more experience than I do on that.
Okay, great.
And you have to come up to the podium because this is JPR and that's how we roll. I've asked to change it many times, and I would like a public poll of getting rid of the podium in JPR. Anyone who wants to weigh in, send it to the committee chairman.
Sure. If I understand your question, it's essentially, does an operator of a motor vehicle have to yield to a cyclist who's kind of approaching that location?
But who's some distance, some ways back?
Sure. So I think it would essentially be the same as any other yielding right-of-way statute with regards to motor vehicles or any other person using the roadway, that there's a reasonableness built into it, that when you're making a left turn at an intersection, for instance, if you're driving a motor vehicle and there's a vehicle approaching from a quarter mile away in essentially the dominant roadway going straight in your direction, going to pass you, do you have to yield to a vehicle that is so far away that it's not reasonably a threat to you at that point? But if that vehicle happens to be speeding or going so far in excess of the speed limit, it gets to the same place at the same time.
Yeah, or is not easily visible. I mean, if I want to turn right, I can see someone who's right there. I could see someone who's a couple of bike lengths back. But if the person is a block away, but is zipping along, I'm probably not going to see a bicyclist. I'll see a car maybe a block away. I wouldn't see a bicyclist. Or it'd be harder for me to see a bicyclist, right? That's what I'm saying.
Sure. And I think built into the reasonableness of yielding the right of way to an individual who is in the bike lane at that time, one of the parts about the statute is it addresses specifically when there's a bike lane or a designated shoulder, which in and of itself is an indication to drivers to be aware and alert the presence of cyclists. If you see that a cyclist is a block or 2 blocks back, I don't think the law would require a driver to yield to that person indefinitely. It's only circumstances in which that cyclist, motor scooter, the other things addressed under this would be in the same place at the same time.
Well, let me ask you this as a follow-up. So in normal tort liability cases, there is a last clear chance theory. So if I do something negligent, but you have an opportunity to prevent injury by, you got the last chance to stop the injury, you are presumed by the law to be required to do what you can to, even though I was negligent doing whatever I did, your responsibility is to try to avoid the injury that will occur. Does the same rule apply in this case? So that if I'm turning right in my car, that if the bicyclist has a chance to stop, it's on the bicyclist to stop and not hit me.
You're taking me back to 1L year with tort law and civil procedure. We don't have the doctrine of last clear chance in criminal law in the transportation article. So it's a little bit difficult to answer that, but I think part of that is the discretion of the judge in the presentation of evidence and the specific facts of an individual case.
Okay, thank you.
Thank you very much. All right, additional questions from the committee? Seeing none, thank you all very much. Thank you. All right, with that, that'll conclude the hearing for Senate Bill 315. We'll now move on to Senator Charles, Senate Bill 672.
There you go.
Thank you, Mr. Chair. Good afternoon, my esteemed colleagues. For the record, I'm Senator Nick Charles introducing Senate Bill 672, straightforward and common sense bill that is intended to save our constituents time and money, something I think all of us could save. Senate Bill 672 requires that jurisdiction use the current mailing address on file with the Maryland Motor Vehicle Administration to send citations and notices issued as a result of automated enforcement. Additionally, if a mailing address is not available, the jurisdiction will also be required to use the current residential address on file with the MVA. I'm sure that everyone in this committee has received letters from constituents about unpaid traffic citations that they did not know about, which then led to an administrative flag with the MVA because of non-payments for the citation. Those customers may not have had an initial opportunity to pay their citations because it was not sent to their most updated address. Then they have to first learn about the citation after receiving the notification from the MVA as an administrative flag was placed on their account. The current process is causing an undue burden and stress on our constituents and should be updated to be more efficient. Senate Bill 672 attempts to do just that. By requiring jurisdictions to cross-reference addresses with the Motor Vehicle Administration, which holds the most updated customer information, we hope to eliminate those unnecessary fees and subsequent administrative flags. For that reason, I respectfully urge a favorable report on Senate Bill 672. And with all that in mind, I'm going to bring up my panel. We got one person, Ms. Christine, who's it, Nizer? From MDOT. All right.
Good afternoon, Chair Smith and members of the committee. For the record, Chrissy Nizer, MVA Administrator, and I want to thank Senator Charles for introducing the bill, which, as he said, is really a common sense measure. Now, for most people, your residential address and your mailing address are the same thing. However, there are several instances in which a customer might need to have a mailing address, somebody that uses a PO box. In some more rural areas of the state, they actually can't get mail delivery at their physical location, and so they have to use that mailing address. And, you know, sometimes people choose to get mail at a different location just for convenience sake. And so in those cases, oftentimes the first notice, as the senator said, really comes from the MVA because we have that mailing address on file, but it's not often used by the jurisdictions. Unfortunately, that does result in that $30 administrative fee. The only way we can waive that is a local jurisdiction saying that the citation was placed in error. Obviously, this creates an administrative burden, and something that challenges the customer. So we really think this is a common sense measure that just creates a more efficient process. It provides appropriate notification, which is what I think we all want, allowing the customer to be able to pay their fine timely and to be able to resolve the issue before it even comes to the MDA. And so for that reason, I would ask for your favorable consideration of Senate Bill 672 and be happy to answer any questions.
All right, thank you very much, Administrator Nizer. Questions from the committee? All right, seeing none. Thank you, Senator. Thank you, Administrator. All right, with that, that'll end the hearing for Senate Bill 672. I see Senator Washington is here, so we'll now move on to Senate Bill 514.
I just love this committee. Thank you, Mr. Chairman. Members of the committee, my name is Alonzo Washington, Senator representing District 22 in Prince George's County. I'm here to present on Senate Bill 514, sidewalk and path maintenance. This bill would transfer the ownership and responsibilities of sidewalks adjacent to state roads from their local municipalities to the State Department of Transportation. Currently, as you all know, a lot of our state roads, they're in municipalities that exist. We have 27 in Prince George's County, and 7 of which are in my district itself. And we know the budgets of our municipalities, they're very small, they're very tight. And so to be able to install sidewalks or even maintain the current ones, if there's a buckling of a sidewalk, or if there's cleaning that needs to happen on a sidewalk that's adjacent to a state road, it just costs too much. It's overburdened for these municipalities. For instance, along the roadway of NASA, near NASA, there's a long stretch of road that's a state highway, and that road has not been well kept by either the municipality or SHA. And so because of that, there's no bike paths on that part of the road. There's no beautification on that part of the road. There's no reinvestments in that road. And so what we're saying is that the burden should be switched to an entity where they could procure these and able to fund these improvements. And so I propose this bill because my constituents came to me and they demanded that I come back to JPR for this bill so that we can make sure that the burden is placed back on the state. Thank you, Mr. Chairman.
Excellent. Thank you very much, Senator Washington. Questions? Oh, actually, we've got 3 witnesses. Let's hear from the witnesses, then we'll do questions at the end. Cool. So save rounds. All right. If we have, is Seth Grimes here? I haven't seen him.
Mr. Chairman, Seth asked me to tell the committee that he was hurt on his way here today.
Oh, no.
Very ironically, he fell on a state sidewalk here on Road Boulevard. He is not able to testify.
Okay, Seth is a friend and a constituent, so I'll call him
He has
tonight.
written testimony.
Okay, we will make sure that we consider his written testimony. Thank you for saying it. Are you here also to testify?
I'm Mr. Lemieux, you got my, request. If it's
Oh,
not on the list.
come on.
It could be that it glitched from Friends of the Greenbelt East Square.
Come on up. Right.
Thank you, Mr. Chairman.
Thank you. And then then we got 2 people joining us virtually.
And they're both.
Okay, got it. So go ahead, sir, and then we'll go to our
Thank
virtual
you.
witnesses.
I'll be super quick. I wanted the Jeff Lemieux from Friends of the Greenbelt East Trail, which is a 501c3 dedicated to getting trails built in Senator Washington's district. This bill bubbled up through District 22, not so much because of a maintenance issue. We weren't worried about beautification. We weren't worried about trash, anything else. This bill bubbled up because when I approached MDOT to do a feasibility study for a trail in our district near NASA and on through Glendale, they said I had to get sign off from the county and the city of Greenbelt that they would do maintenance in perpetuity on whatever the state built. And in our county and we may have some cities that will sign off on those sorts of things, but the county DPW&T and the city of Greenbelt, they didn't want to do that at first. I had to pull teeth to get them to send the letters. We finally got the letters off to MDOT. The feasibility studies are underway and we're going to get this done. But in the meantime, I approached Delegate Healy and said, there's this clause about maintenance that's really holding up our feasibility study. And she remembered that from when it was originally enacted, and she agreed to sponsor the House Companion Bill 389. And the purpose was just to strike the clause that requires the localities to do maintenance regardless of what the state builds, and instead leave it more vague. There's other bills that would transfer the responsibility more affirmatively to the state. We didn't go that far in this bill unless something's changed very recently. instead just took out the requirement that the locals have to do it, to leave it more open as to who would eventually do maintenance and how, and allow that negotiation to happen. So just with that bit of background, I'm happy to answer further questions of how this bubbled up out of District 22 and how it was an impediment to us getting an MDOT study for a trail in our district.
Excellent. Thank you very much. Let's hear from our two virtual panelists and then we'll open it up for questions. Ms. Court, let's welcome. You're up.
Thank you. Thank you, Chairman. My name is Cheryl Court. I'm with the Coalition for Smarter Growth. We are working in the Washington, D.C. region, including suburban Maryland, advocating for walkable, bikeable, inclusive, transit-oriented communities as the most sustainable and equitable way for the D.C. region to grow and provide opportunities for all. We are here to express our support for this legislation. This bill would remove a requirement that the maintenance and repairs be always assigned to the local political subdivision. We think this is an impediment, or we know that it's an impediment to the construction of needed sidewalks in urban areas close to metro stations like Maryland 410, for instance, and other parts of Prince George's County in particular, where I focus a lot of my work. By removing this rigid assignment of maintenance and repair costs from the local government, we can create a more negotiated partnership between the state and local authorities, how best to work out the maintenance of a sidewalk on a state road. And as you probably are aware, Prince George's County leads the state in traffic deaths and pedestrian deaths. This is an important tool that we need to make sure that we can build more of the safe infrastructure that Marylanders need and that Prince George's need. So we ask the committee to give a favorable report for this legislation. Thank you.
Dan, you're up. Welcome.
Thank you. Thank you, Chairman Smith and the Judicial Proceedings Committee members for the opportunity to speak with you today. My name is Dan Barron. I'm a resident of District 22 in Prince George's County. I also volunteer with several organizations working to make Maryland's streets safer, including on the boards of Bike Maryland and the Friends of the Greenbelt East Trail. I strongly support Senate Bill 514, and I urge the committee to report favorable on the bill. As Ms. Court mentioned, Prince George's County has the unwanted distinction of leading the state of Maryland and Washington, D.C. region every single year in traffic fatalities, including for pedestrians and bicyclists. Historically, about 80% of those fatalities have occurred on state-maintained streets in our community. Many of these streets lack needed, adequate, and safe places to walk, bike, and roll. SHA's move to context-driven design and recent strategic plans acknowledge the need to update policies to fill gaps in our active transportation network, which includes sidewalks and bike paths. The prohibition that this bill proposes to remove has caused pedestrian and bicycle safety projects along state-maintained roads to be delayed or stalled. While the change does not require SHA to assume maintenance, it removes an administrative obstacle of getting needed sidewalks and bike paths designed and built along SHA-owned and maintained roads. SHA deserves a lot of credit and praise for recently completing a half-mile extension of the Rhode Island Avenue Trolley Trail in Hyattsville. It's a project that's been in planning for over a decade. That trail has been transformational and giving people opportunities to travel safely through the community. Now the community further south is looking to see how that trail can be extended a few more miles to the Washington, D.C. border. I feel this bill, by removing an administrative hurdle to planning and construction, will help needed projects like this one get built. Again, I strongly support Senate Bill 514, and I urge the committee to report favorable on the bill. And thank you again for your time today.
Thank you very much. Questions from the committee? Senator West.
Thank you, Mr. Chair. So I want to focus, the gentleman sitting there to the left, I can't recall your name.
Jeff.
Jeff, could you stand up there to the podium? You were the one who said we need to leave it more vague. And as I read the bill, if we take out this requirement, there's no requirement in the law that anybody maintain the sidewalks or the bikeways. Is that how you believe the situation would result if we pass this bill?
In Prince George's, no one maintains the sidewalks already. So we feel as though there would be no difference in our area. And there's plenty of easy to see evidence of that on our streets.
So would you anticipate that if we pass this bill statewide, we would find crumbling, decrepit sidewalks?
We
and-
don't. We feel as though in other counties in particular, and the reason we didn't ask for a bill that required SHA to just do everything is because they already have some arrangements with some of the more wealthy counties to do some of this, and they have some give and take. For example, in Montgomery County, from what I understand, and also Anne Arundel, we just don't have any of that. So we don't feel as though those negotiated agreements will be changed. We don't feel as though it'll affect maintenance in Prince George's County really at all on state roads, except possibly a little bit in the city of Bowie or in the city of Hyattsville might do a little bit of maintenance already. They're going to continue to do that. We feel as though the main thing from our point of view is getting new protected facilities, particularly for bike riders, built. And if this clause was an impediment to getting those studies done for, quirky legalistic reasons, we would much prefer to just get rid of it. And as in agreement with SHA, we decided not to put the full responsibility on them right away because their director came to our event last week and said that would be too much too soon. Let's just ease into this by getting rid of this administrative clause and move forward from there in a negotiated way.
Okay, well, I can't find it right at the moment, but I think that I read in the testimony that Anne Arundel County supports this bill because they say it will save the county a lot of money.
I'm not familiar with that.
Passes. I can see counties which have in the past have worked out arrangements with SHA to maintain sidewalks and bikeways saying, okay, we no longer have to do it. This General Assembly has repealed that obligation. And so we're not going to do it anymore and just sort of leave it to SHA, hoping SHA has the money to maintain these sidewalks. And if HA had, as we know, SHA is money constrained. I can see SHA saying, well, this is a lower priority for us than some of the other things. We're just not going to do it. So isn't it possible that if this bill passed, we will end up with sidewalks and bikeways throughout the state not being maintained at all by anybody?
I don't know. I know that it won't affect us in Prince George's County, and that was
There's already the county's not maintaining them.
That's correct.
Okay, thanks.
All right, thank you, Senator Washington. Thank you all. With that, that'll end the hearing for Senate Bill 114. We'll now move on to Senator McCray, Senate Bill 652.
Thank you, Mr. Chair. Mr. Chair, Mr. Vice Chair, for the record, Corey McCray, serving as the senator for the 45th Legislative District, and I come before you in reference to Senate Bill 652. Mr. Chair, Senate Bill 652 is a product of something that you know that I do. I've said it repeatedly, but I'll repeat it one more time. I meet with my colonels, lieutenant colonels, my major, and commanders within my district to understand each and every homicide and non-fatal shooting within my district. The thing that I do different here, Mr. Chair, is that when we would have multiple juveniles that were shot in my respective district, I would reach out to the DJS secretary at that time, who was Sam Abed, and saying what kind of help me understand what does the after action look like and how long did it take for his respective staff to put a hand touch that respective juvenile. Mr. Chair, I tried to do what I'd always done when it had happened over the summer in my district. I believe in the month of July, I reached out to the new respective secretary, and unfortunately my request at the time had went unanswered. So in response to that unanswered, I found myself putting in and thinking like, Corey, why am I having these one-on-one conversations? This should be something that's accessible to the public. It should be accessible to legislators and things of that nature. So I put what we were doing into a bill. Since that time, I want to say the last 4 weeks have been moved in the right direction with the respective secretary. The agency is supporting the bill with the amendment, and I agree with the amendment. And there is a cordial relationship that has been established and hope to be cultivated during his tenure as our respective secretary from that standpoint. So I would ask for a favorable report for Senate Bill 652. There's zero opposition. The agency's on board, and I will be supporting the amendment that the agency does have.
Thank you very much, Senator. We are in receipt of the amendment and glad to hear your feedback. So it's very helpful for us moving forward.
Yes, sir.
Questions from the committee?
This is a first.
Excellent. Hey, it's a good bill. So thank you for bringing it
Thank
forward.
you.
Thanks. All right. With that, that'll conclude the hearing for Senate Bill 652. We'll now move on to. All right. Senator West, you want to go with your bill since you've got just one witness?
Yes.
Senator West, Senate Bill 636.
Thank you, Mr. Chair. It's a pleasure to be here to present Senate Bill 636. You'll notice I have no witnesses for this bill. I really don't think I need witnesses because we've heard so much testimony at various times during the course of the session and the briefings we had at the beginning of the session on this issue that I don't think witnesses are really required at this juncture. So this is perhaps my most important bill of the session because of the imperative short and long-term impact it could have. As we're all aware by now, both chambers of the General Assembly and the governor have signaled their intention to make juvenile justice a top priority this session. Regardless of which side one might fall on the policy issues presented by the various juvenile bills pending before us, I think we all agree that it's absolutely essential that the state of Maryland be in a position to provide effective treatment services to juveniles who've gotten themselves in trouble. Accountability and effective treatment for juveniles committing crimes is imperative. But repeated testimony that we have received confirms that this is not occurring at the present. For example, this committee has received reports that one youthful offender after another has received no treatment services because, quote, there are no slots available, close quotes. Such a situation is intolerable. To get to the bottom of this problem and to solve it, I present to the committee Senate Bill 636. If passed, this bill will establish a commission to study how effectively the Department of Juvenile Services can provide social services to juvenile offenders. The commission will be comprised of a member of the state Senate appointed by the chair of this committee, a delegate appointed by the chair of the House Judiciary Committee, an appointee of the Department of Juvenile Services, an appointee of the Office of the Public Defender, an appointee of the Maryland States Attorneys Association, an appointee of the State Police, and an appointee of the Attorney General. A small select group of people who can bear down on this issue and solve it. And the best way for me to describe the mission of the proposed commission is to simply read to you the mission statement contained in the bill. It says, the commission shall, 1, review and assess the efficiency and effectiveness of the policies and practices of the Department of Juvenile Services relating to A, the supervision and monitoring of juvenile offenders, B, treatment programs, C, intervention and prevention services, D, rehabilitative services, E, community supervision, and F, mental health services provided to juvenile offenders. Then continuing, 2, consider available evidence-based assessments of Department of Juvenile Services programs. 3, develop data relating to the number of juvenile offenders and the length and frequency of juvenile participation. 4, investigate the effectiveness of DJS programs and services aimed at juvenile offenders. 5, assess the total cost associated with DJS programs and services within the past 5 fiscal years. 6, make recommendations regarding improvements to DJS residential programs. 7, assess and make recommendations regarding the ability of the Department of Juvenile Services to provide social services to juvenile offenders. And finally, 8, make recommendations regarding budgetary appropriations to sustain and improve DJS programs and services. Upon reviewing the draft bill prior to this hearing, I realized that an amendment is needed. Currently, the bill requires the commission to render its final report by December 1st, 2025, and provides that the commission will sunset on December 31st, 2024. Obviously, that timing doesn't work. The amendment will provide that the commission's final report will be due by December 31st, 2024 at the end of this year. So we have the information to develop legislation for next year. And secondly, that the commission will sunset on June 30th, 2025. It's vital that this commission have the commission's work, this committee have the commission's work product in hand at the end of this calendar year so that appropriate implementing legislation can be enacted in next year's session. So the question, I guess, right now is whether we should enact this as a separate bill or instead import this into the bill which the chair of the committee and the president of the Senate has submitted on juvenile justice reform. The problem with the bill that the president of the Senate and the chair of this committee have proposed is that it contains a provision for a very large commission with dozens of members, and its purview covers from A to Z everything related to juvenile justice. This is a much more targeted bill to be done in a short period of time with a small number of people to focus intensely, like a laser beam, on juvenile services and their inadequacy and what needs to be done to bring them up to snuff. So we could import this bill into the larger bill that the president and the chair of this committee are proposing, or we could enact this bill as a standalone independently of that bill. Either one, it seems to me, work. And with that, I leave the bill to you and request a favorable report, and I'm willing to answer questions.
All right, thank you very much, Senator. Questions from the committee? All right, more work forthcoming.
Thank you.
Thank you. All right, with that, that'll end the hearing for Senate Bill 636. I see Senator Benson is here. Senator, let's go with Senator Simonaire first. I know you arrived first, and then we'll move on to Senator Benson. So Senator Simonaire with Senate Bill 584. Welcome.
Thank you. And for the record, Senator Simonaire, Senate Bill 584. I typically like to just bring a couple witnesses and provide written testimony. The flaw of that plan is when somebody gets sick. So Pat Cabot with the American Legion supports this, but he got sick, so he will not be here today. I'm pleased to say this is a consensus bill. I've worked collaboratively with the Department of Veterans Affairs and other military organizations and appreciate their support. I've also worked with many others, including MACO and MML, and there's no opposition to this bill. Senate Bill 584 is a simple concept. As you know, the MVA already has license plates for Military Combat Award recipients and Gold Star families. This bill would utilize those license plates to honor those who have done so much for Maryland and our nation. Also, the goal is to promote veteran suicide prevention by engaging more veterans. And this bill supports Governor Moore's goal of making Maryland the most military-friendly state in the nation and making 2024 the year of the military families. As amended, specifically, this bill waives the street side public parking meter fees for those who have a Maryland Combat Military MVA license plate or a Gold Star family license plate. As to implementation, these tags are definable and identifiable and easy to recognize. And we have passed similar legislation saying that only one motorcycle in a metered parking lot can be charged and the others are waived. I wish I could say this is the first in the nation to do this, but there are other states that have provided this honor and even greater scope. However, I believe this is a good starting place as the scope of this bill covers about 1,600 combat and Gold Star members in our state. And secondary benefit of this legislation is that it creates another tool to promote veteran suicide prevention. As the word gets out, more combat veterans will likely get these publicly visible plates, engage more with the public as people thank them for their service and other veterans recognize them. Hopefully, with more engagement, there will be more opportunities to discuss shared experiences and available treatment for any suffering in silence. The committee has shown that small but meaningful acts are valued, such as the administration's Senate Bill 275, which you heard and passed, that waived the new registration fee for Gold Star members, including next of kin. One bill by itself does not accomplish our goal of becoming the most military-friendly state in the nation, but collectively we can make changes to put us on the path of success. Personally, I had the privilege as a civilian to serve alongside our brave military men and women in a war zone, and I can tell you they deserve all we can to help them and honor them. Senate Bill 584, while modest, is an excellent way to say thank you for our military and Gold Star recipients.
I have submitted an amendment as discussed with the committee that is supported by the department. I ask for your favorable consideration. Thank you.
Excellent. Thank you very much, Senator. Questions from the committee? All right, seeing none. Thank you very much.
Thank you.
Thank you for the bill. All right, that'll conclude the hearing for
I
Senate Bill.
believe we had one.
Oh, I'm sorry. My apologies. You're right.
Yeah.
Joseph Dolan. Yep. If you could come to the podium, that'd be great.
Absolutely.
Thank you very much.
Sir. Maryland Senators, thank you for your time. My name is Joseph Dolan. I'm a resident of Anne Arundel County. I'm here to seek support for Senate Bill 584. I'm in favor of this bill as it would have a meaningful impact on me and my family. This law would change laws for parking in Maryland for combat decorator veterans. As a specific example, I'd like to reference the state of Texas. Current legislation in Texas allows veterans with specific military decorations to park in public for free anywhere in Texas. Clearly, Maryland is home to multiple bases such as Fort Meade, Andrews Air Force Base, U.S. Naval Academy. Veterans who have served and continue to serve at these locations are important members of our economy and our community. Many of them have made significant sacrifices, and I think it would be right for Maryland to support them with this simple but important benefit. I was in the Navy for 10 years as a pilot, and for my full-time job, I'm an airline pilot and work out of BWI. Like many of my coworkers, I flew combat missions in OIF and OEF, and I've been awarded an Air Medal for that service. Texas has stood up and thanked their decorated veterans, and I think Maryland can and should too. I'd also like to note that when combat decorated veterans were asked to accomplish a task, they didn't hesitate. I don't think Maryland should either. In conclusion, I strongly support this legislation in order to thank and support Maryland's combat decorated veterans. I appreciate your time and consideration. I look forward to moving this issue forward. Thank you.
All right, thank you very much, Senator. Questions from the committee? All right, seeing none, thank you both very much. Thanks. Now that will conclude the hearing for Senate Bill 584. We'll now move on to Senator Benson with Senate Bill 724. And Senator, we can bring up your panel if you like. Come on up, Senator. And we've got Kristen Poland. Is Juliana? Juliana's here. And all right, Senator.
Isn't she precious?
I'm not showing any favoritism, but my daughter and Juliana go to school together, so we're so she's got a head start in this whole thing right now.
Good afternoon, Chairman Smith and Vice Chairman, members of the committee. Lord have mercy. It is an honor to be here before this esteemed body once again. I'm here to ask for your unfavorable report on Senate Bill 724, Motor Vehicles, School Buses, Seatbelt. Senate Bill 724 is designed to safeguard our students during their daily commutes by mandating the addition of seatbelts on all school buses. This initiative not only aligns with the safety standards recommended by the National Highway Traffic Safety Administration, but also empowers states to establish and enforce seatbelt laws specifically for school buses. Although the National Highway Traffic Safety Administration recognizes the inherent safety of school buses, allowing states the discretion to require seatbelts. This bill represents an effort to standardize safety enhancements, enforcements across the board. The risk of student fatalities in school bus related incidents though small, is significant, with an average of 4 students losing their lives each year. This risk, we believe, can be negated through the implementation of seatbelts, a stance supported by evidence from states such as California, Florida, and New York, and findings from studies like the one conducted in Alabama demonstrating the efficiency of seatbelts in enhancing bus safety. The potential benefits exist far beyond the physical safety of students. For example, the introduction of seatbelts has been correlated with improved student behavior on board, as evidenced by the experiences of the Bartholomew Consolidated School Corporation in Indiana, which reported few disciplinary issues on buses equipped with seatbelts. This improvement can also contribute to easing the challenges faced in recruiting and retaining bus drivers, especially important considering recent shortages that have led to dire consequences as seen in the tragic incidents in Riverdale, Maryland. It is crucial to note that while school buses are designed with I'm sorry. I've had a hard morning, but I hope you all will forgive me for this. It's crucial to note that while school buses are designed to compartmentalize in protecting passengers, the National Transportation Safety Board has identified limitations in this design, particularly in the event of side impact crashes and rollovers. The unfortunate accident in Chattanooga, Tennessee, serves as a stark reminder of the gaps in our current safety measures and the pressing need for this legislation. Senate Bill 724 represents a proactive step toward enhancing the safety of our children on school buses. It is a measure that rests not only addressing the evolving standards of transportation safety, but also reflects the concerns and aspirations of our communities for a safer, more secure commute for our children. By endorsing this bill, we're not just complying with best safety practices, we are also sending a clear message about our commitment to the well-being of our children. I want to also read to you the last paragraph from the National Transportation Safety Board. They are in support of this bill. It says, although compartmentalization makes school buses currently safe, passengers without lap shoulder belts remain vulnerable to either ejection or injury within the school bus. For example, from being thrown into or an intrusion area. Therefore, to protect large bus passengers, we recommend that Maryland amends its statute to require passenger lap shoulder belts for all passengers seating positions in new large school buses in accordance with the Federal Motor Vehicle Safety Standard 222. Thank you.
Excellent. Thank you very much, Senator. Then we'll hear from Ms. Poland from the NTSB, and then we'll move on to Juliana.
Thank you.
Good afternoon, Chair Smith, Vice Chair, and members of the Judicial Proceedings Committee. My name is Kristen Poland, and I'm the Deputy Director of the Office of Highway Safety at the National Transportation Safety Board. I am also a resident of Crofton, Maryland. I am here to testify on Senate Bill 724 and why mandating passenger lap shoulder belts on large school buses in Maryland is the right thing to do. First, I want to make it clear that school buses are the safest way for children to get to and from school and school-related activities. As I've explained in my written testimony, this is because of a number of safety requirements for school buses, including compartmentalization, which is a passive occupant protection system. However, in my 25 years at the NTSB, I've investigated numerous crashes where compartmentalization was not enough to prevent injuries and deaths, especially in side impact crashes with other large vehicles, in school bus rollovers, and when pre-crash bus maneuvering throws children from the protective seat compartment. Properly worn passenger lap shoulder belts would have lessened injuries and even saved lives. While we are not investigating the recent bus rollover earlier this month in Maryland, we know that children are at risk of ejection from the seating compartment and from the bus itself in rollovers. Passenger lap shoulder belts provide the best protection, keeping students within the bus and reducing injurious impacts with other passengers and with hard structures. We also investigated crashes with lap shoulder belted equipped buses, and we found that passengers who were wearing the lap shoulder belts had their injuries mitigated. In summary, to best protect Maryland students who ride in school buses, we recommend that Maryland amend its statute to require passenger lap shoulder belts for all passenger seating positions in new large school buses. And I'm happy to answer your questions when appropriate.
Excellent. Thank you very much. Great.
Hello, Chairman Smith and committee members. I am here to ask for your favorable report on SB 724 motor vehicles, school buses, seat belts. My name is Juliana Echo Nunez. I'm in 4th grade at Sidwell Friends School in Montgomery County, where I also live. After my dad got his job as the chief of staff for Delegate Denny Taveras, I asked him if he could help make school safer because of something scary that happened to me on a school bus. One time during a field trip, our bus made a really quick turn and I almost fell off my seat onto the floor. It was very scary. Then on another trip, the bus stopped so suddenly that I had to put my arms up to protect my face. It made me feel really scared and confused. Also, my dad showed me a news story about a bus that flipped over. The driver was okay because he had a seatbelt, but the kids got hurt because they didn't have any seatbelts. That made me think it's not fair for us kids to not have seatbelts when it can be so dangerous. I know adding seatbelts to buses might cost more money, but keeping us safe is really important. I want to be an artist and start my own business when I grow up. I'll pay taxes, but I need to be safe and healthy to do that. Please ask the policy analyst to consider my earning potential when updating the financial impact of this law. In closing, I ask this committee for your favorable report on SB 724.
That was fantastic testimony. Jacqueline's going to be jealous that you got to hang out with your dad, come see, JPR. That was excellent testimony. When you get back to school, can you tell Jacqueline I said hello? I don't see her often during sessions, so, All right. Questions from the committee? All right. Of course. It's up to you. Go for it. Senator West has a question.
So I think for the lady there on the far right, if I could. Ms. Poland, thank you. I would ask a question of Jacqueline's friend, but I wondered what your earning potential was, but we won't go there.
After that testimony, I'm sure it's very high.
So I had a visit from some school bus people the other day, and my original inclination was, of course, this bill is perfect. And they suggested there are a couple of respects in which it's not. One in particular was, they said during the first week of school, they have no idea how many kids are going to get on the bus. Now, I come from a private school background, so my private school knew exactly who was enrolled, and they could assign buses to pick us up and know exactly who's going to be at what corner. But apparently in the public school world, you don't know who's going to be on the corners when school first starts. It could be 3 kids, it could be 8 kids. And so they said in the early going, they have to have the ability to have kids stand on the buses because otherwise they would end up being full and then would have to drive the rest of the way to school and pass by other kids standing on the corners. How do you deal with that?
I can tell you what happens in Crofton, Maryland. They have children register for the school bus so that they know how many children could potentially be on the bus that day. And of course, they have to account for the total seating capacity of the bus. Having students standing in the bus is obviously incredibly unsafe. Any sort of braking maneuver, the children wouldn't be protected by any of the compartmentalization at all. So that practice obviously is not safe at all.
Okay, let me ask you the other question. They said that there was a situation where a bus rolled over on its side. And they said if there had been seatbelts, the kids on the high side of the bus after it rolled would have been left dangling in the air. Whereas if there weren't seatbelts, they would have slid off their seats and across the aisle and ended up sitting against the seats on the downside of the bus rather than dangling up in the air until somebody could come and rescue them. Do you have a response to that?
Yeah, it's a common misconception. People think that the rollover is gentle and that the children will just gently slide off the seats and come to rest on the far side. In fact, most rollovers are violent. And so those children are not just gently slid off the seat, they're actually propelled forward and then they fall the long distance, impacting other occupants in the bus, potentially causing injury, or impacting portions of the bus that aren't designed to be impacted. And so, of course, if you're dangling up high, then you have the opportunity to unbuckle your belt and get down safely, or if necessary, somebody can come in and assist those children. But these belts are designed so that they can be unbuckled even when they're in a loaded condition, like when children are hanging sideways.
Great. Thank you for answering my question.
You're welcome.
All right. Further questions from the committee? All right, Senator. Thank you, Ms. Poland. Juliana, great job. All right, that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. We have Mr. Bruce Boreano and John Willems, Jeffrey Thompson, and Brianna January.
Good afternoon, Mr. Chairman, members of the committee. For the record, Bruce Boreano. I'm here on behalf of the Caroline County Commissioners in opposition to this legislation. I know it's a very difficult act to follow. I'll do the best I can. The county commissioners, of course, are not opposed to seatbelts and they're not opposed to safety. But picking up the colloquy between Senator West and the other witness, there's another reality that you have to keep in mind. We're all about safety. We don't want people hurt. But bear in mind, there is only one adult on this bus. That's the driver of the bus. There's only one adult on there. And God forbid there could be circumstances where, depending upon the accident or the crash or what have you, I mean, we don't know. There are all sorts of things that could happen. That bus driver could be killed or incapacitated or trapped in its driving seat. And who is to assist the children of various different ages? There's going to be a lot of panic, a lot of fright, a lot of people scared, very understandably. But they may not be able, in that state of mind, in that situation, or given their age, to unbuckle themselves quick enough, whether it's a fire, whether it's a crash. That is the concern of the county commissioners with the requirements of this bill. If there were another adult in the bus to be available to assist the children in such a tragedy, and there's so many different kinds of tragedies, that would be different. But the lack thereof and the children being fixed and stationed in the seat, you, God forbid, could have circumstances where that creates more injuries and deaths than otherwise would be the case. So they wanted to express that view to this committee that really needs to be taken into account. This is not a simple matter in reality. Thank you very much. Be happy to answer any questions.
We'll take questions after the panel. Thank you, Mr. Boreano. We'll take questions at the end of the panel.
Oh, I'm sorry.
No worries. Mr. Willems.
Mr. Vice Chairman, members of the committee, John Willems representing the Maryland Association of Boards of Education. The committee has made written testimony in opposition to the bill. And to be clear, I was signed up in opposition. But a shout out to Juliana's father, Jason Nunez, staff to Delegate Taveras. He reached out to us We are in the process of agreeing to a set of amendments to remove the retroactive provision of the bill, which of course is identified as extraordinarily costly in the fiscal note, to move the implementation date forward for the purchasing of new traditional school buses, large diesel school buses with seat belts, to FY 2027, starting July 1 of 2026, and to address a couple of the other provisions of the bill related to the prohibition on students standing when the bus is moving, and another amendment that I understand from the bus contractors addressing the liability of the bus driver in cases in which there is not compliance with the standard, right? Because a bus driver can't leave his or her seat to ensure that kids are strapped in. That violates other laws related to the safe operation of a school bus. And so with all of those amendments, to the best of my knowledge, being agreed to by both the House and Senate sponsors of the bill, MABE is testifying today in support of the bill with amendments. Thank you.
Great. Who's next?
Good afternoon, Vice Chair, members of the committee. I'm Jeff Thompson. I'm the Director of Transportation for St. Mary's County Public Schools, and I'm also the current president of the Maryland Association of Pupil Transportation, which represents the professionals in pupil transportation from all 24 LEAs. There are two major concerns that we had with the initial iteration of 724, but the amendments do make it this different, but I will go through the concerns just so you know. The two major concerns, as Mr. Williams has mentioned, are one, the retrofitting of school buses. There's not a supply of seats available for manufacturers to actually meet that requirement. And if they did, the time frame would not happen, and the cost would be exponential, as you should have seen in your fiscal note. And we have over 10,000 school buses in Maryland, half of those being the public school buses that need to get done. And you'd be looking at well over probably $100 million to do that. So it would be extremely costly, but there is really no seats to do that. And then third, the manufacturer said they would not back up their product because if we reinstall seats that were not originally installed at the factory, then they would not support any liability issues that would come from an accident or whatnot if those seats were to detach in those accidents. The second concern, which may be the bigger concern, is honestly the burden that the current iteration of the first iteration placed upon the school bus drivers, that they can't operate the school bus unless each passenger is restrained by a seatbelt. And our bus drivers, they do the best they can do. But as you all know, sometimes students aren't the most compliant with what happens. The bus drivers try to take control and manage the bus the best they can, but sometimes traveling down the road, things do happen. And the best course of action is just get the kids to school or get the kids home and then let an administrator deal with those situations the following day or that afternoon in a school discipline aspect. So please, with our current driver shortage and the issues we face with drivers, please do not place this burden upon them. So again, thank you for your time. Thank you for listening to our concerns.
Thank you. Questions for this panel, Senator Muse?
Thank you very much. And this is to either one of you, but particularly those of you on the end. I've been here almost 20 years and I've heard this bill or something like it for probably 20 years. So my only concern is I hear you, but you come each year and give the same reasons for not doing it. What I'd like to see done is for you to come here and tell us what you need to do and what is your plan for getting it done, because we can't keep losing children's lives or they breaking bones and all that sort of thing. And thus far, I've not heard anything that with a strategic plan and a timeline, you can begin moving toward, even if it starts with the elementary kids first. Okay, how long does that take? What does it take? What do you need from us? But I would hope that this bill will not be in front of us again. And I would hope that if it is, you will go back and just give me some better ideas. Give me some kind of strategic plan as to what you would do to move toward it so that 15 years from now, when almost the whole present fleet that's 10 years old, up till that time, 25 years, has not been replaced, and you're still coming down saying the same thing.
Well, that's a big question with a lot of pieces to it. I will start by saying in the state, and as far as public schools, for the most part, I would say most of the public school systems with their special needs buses have already transitioned to having seatbelts installed in those buses. So that's one aspect that, like myself in my county, 12 years ago, we started it. So now we're hitting our replacement cycle. So now all of our buses, special needs buses, have seatbelts on them. So 12 years ago, that wasn't the case, but now it is.
Which county is this?
St. Mary's County.
Okay, because it's not
And
good.
I would say throughout the state, though, on the special needs buses, that's a lift with the lift, the smaller buses with the lifts, that's almost become commonplace to have seatbelts. So we've kind of gone that route with it. There are 4 counties, myself included, that are going forward with 3-point seatbelts on buses. So it is in the process of moving forward on their own with counties doing that. And then I would also say that the electric buses that are in the Climate Solutions Now Act to come forward, the requirement is that they have to come standard with 3-point seatbelts on those buses.
Okay, then what you all may want to do is to give an amendment to the bill, or to change your testimony from being in opposition to it. Change it to, we are now moving to comply with this bill, and here's what we need. And given time, whatever that amendment needs to be said. But when it comes to the safety of children and all of these years, and people are driving, as you know, they drive like maniacs, and they don't care about school buses, right? It's different than it was 20, 25 years ago. It's just enhanced, and people are just enraged. I'd like to see you go back to your folks and go back to yours and say, we're not really looking for opposition. We're looking for how to become partners and develop a strategic plan for getting this done, whether it's 5 years, 10 years, 12 years. Come back and work with us, but no more opposition.
I think as Mr. Willems had mentioned, we spoke to Mr. Nunez. And so there is amendments that we've just learned about, that are now in the works to come forward. And so
you're actually favorable with amendments.
And so there would be,
okay, that's what I want to see.
It's an implementation process that's more manageable, feasible.
That's what I want to see. Okay, thank you.
Senator Folden.
Mr. Chair, do one of you have I'm a data oriented person. So do one of you have the statistical data on the number of bus crashes that involved injury over the past year in the state of Maryland?
I do not off the top of my head, Senator, but I could certainly work to get you some data. MABE provides the property and casualty insurance through a group insurance pool for 20 of the 24 local school systems, including bus driver training and risk loss control trainings around student transportation safety. So I could certainly.
Yeah, I just think it's an important thing to look at. Again, we've had this bill a lot. It keeps getting not moved because of the quantifiable fiscal note, which is significant. And just want to try to find a way moving forward, like how much is the increase on a bus to build a bus right now with the compartmental seats, because they're still the same seats, they're just adding seatbelts, correct?
Correct. So it's
yes.
Because they're built currently to be compartmentalized, almost like block cubed areas for the kids in the event of a frontal or rear collision.
To upgrade the seats for a 72 passenger seatbelts, which is a 24-row bus, it's about $8,000 to $10,000 to upgrade. Now to retrofit though.
No, I'm not talking about retrofit. I'm talking about
the retrofit.
How much it is additional at the point of purchase.
It's about 8 to 10.
Okay.
Per bus. But I mean, you take into context, buses this year have gone up almost 20,000 without us doing anything because of emissions. And
welcome to the wonderful world of the U.S. economy currently.
Right.
Amen.
All right. Thanks.
Thank you, Senator West.
Oh, I meant to turn it off.
All right, any more questions for the from the committee for this panel? All right, seeing no questions, I think is Ms. January here? All right, Ms. January is not here, so that concludes the hearing for Senate Bill 724.
Thank you.
Senator McKay, you have a couple bills left, but we're going to take 504.
Yes. Can I bring my panel up, sir? Thank you, sir. Well, thank you, Mr. Chair. Thank you, members of the committee. Thank you for allowing me to present Senate Bill 504. This is similar legislation that was passed in both houses of the General Assembly last year. However, an amendment that we put in the Senate did not get reviewed in time before sine die. What this bill will do is establish the new regulatory system that will apply to RV manufacturers, distributors, and dealers in places like District 1. The regulation will also establish new procedures, timelines, and requirements that govern written dealers of agreements and warranties in RVs and other manufacturing dealers' relationship matters. Similar bills have been passed in 18 states, including the neighbors of Pennsylvania, Delaware, and Virginia. And before I ask for a favorable report, I'd like to let you know that House Bill 605, the companion in the same posture, just passed the House of Delegates 137-0. With that, I urge a favorable report. And if I may, Mr. Chair, allow my panel to speak, sir. Huh?
Thank you, Mr. Chairman. Members of the committee, I'm Michael Oakes, Director of Government Affairs for the RV Industry Association, the National Trade Association, representing RV manufacturers and their component parts suppliers, who together build more than 98% of all RVs produced in the United States. I'm here today in strong support of Senate Bill 504, Senator McKay's bipartisan, bicameral bill to govern the relationship between RV manufacturers and dealers. If this legislation seems familiar, there's good reason. Similar bill was approved last year as House Bill 1173 unanimously by this committee and by the full Senate. And as Senator McKay noted, the House version of the bill was passed this morning on a unanimous vote. RVs do have some similarities to automobiles in that they all have wheels, they're regulated by NHTSA at the federal level, and they travel on the roads of this country. But when it comes to the business models used by the two industries, they are quite different. The RV industry operates on a one dealer to many manufacturers model with no true franchise relationship between parties, while the auto industry is one dealer to one manufacturer. Trying to put the RV industry into the auto franchise law is the proverbial square peg in a round hole. To address this issue, we're asking this committee to support SB 504 to create a separate chapter of law for the RV industry. This legislation is the product of negotiation between the RV Industry Association and RV dealers in Maryland, who are also represented here today. Passage of this legislation will strengthen the viability of the RV industry in Maryland to the state's benefit and that of consumers, manufacturers, and dealers alike. We urge all members to vote yes on this bill and advance 504 to the full Senate. Thank you, and I'd be happy to answer any questions.
I'm Greg Merkel, President of Leo's Vacation Center and a longtime member of the Maryland RV Dealers Association. Thank you for letting me talk before you. This bill would make it a better playing field for the RV dealers and the manufacturers to know what is agreed upon or expected to carry on a relationship, a business relationship It'll also help us provide the consumer better service, warranty, parts, and support after the sale, where we can negotiate with the manufacturers on behalf of the consumers. I would urge you to, the RV dealers are in favor, Maryland RV dealers are in favor of this legislation. I'd urge you to make it favorable. Thank you.
Thank you for your testimony here today. Is Ms. Mercado here as well? Okay. Any questions for this panel? Seeing no questions, thank you, Senator McKay. Will you, that concludes the hearing. That was.
Yeah.
That concludes the hearing on Senate Bill 504. Senator Folden will next take your bill, Senate Bill 601.
Panel chair. So, Mr. Chairman, esteemed colleagues of the Senate Judicial Proceedings, it's good to be with you. For the record, Senator William Fulton, Frederick County Legislative District 4. Senate Bill 601 is, we've had the unfortunate circumstances where juveniles are victims of different terrible actions, whether it be they were trafficked, whether they've been abused, whether they've been through other things that because of their age, they're unable to escape from. And as a result of those unfortunate incidents, we've had juveniles that have resorted to trying to break out of that behavior. And in doing that, there is times that in an act to break out of that behavior, it becomes a life and death situation for them. And they may end up in this adult court system as a result of those acts. And 601, as in front of you, would allow the court, providing that there is clear and convincing evidence that an individual whom the minor had the unfortunate experience with and had previously committed a sex crime against said juvenile or human trafficking, that under the criminal law article, the minor for which they were convicted of the crime would be able to be transferred to the juvenile court for sentencing. So I think this is an important bill in light of the experiences suffered, the terrible circumstances that some of these children are put into, and they feel that their only way to get out is through a fight for their life. And sometimes those fights have terrible results, and we need to show that there are accountability, but they're taking responsibility for these actions at the same time that these actions and these circumstances have put these children in an unwinnable situation that they have to choose between staying in a sex trade or sex trafficking or these crimes being perpetuated against them, or their own life or the life of the person that is, I guess, in charge of them, is a lack of a better word. So with that, I would urge a favorable report on Senate Bill 601, and I would like to turn it over to the panel.
Good afternoon, Mr. Chair and committee members. My name is Emily Virgin, and I serve as the Director of Advocacy and Government Relations at Human Rights for Kids. Senate Bill 601 seeks to address a troubling trend that we have unfortunately seen across the country: the prosecution of child victims of sex crimes and trafficking who have harmed their traffickers or abusers. Many of these children receive lengthy prison sentences in adult court. And because of this trend, legislatures across the country either have adopted or are considering adopting similar policies. The premise behind this bill is simple. Children who have been trafficked or abused who take action against their abuser should not be sentenced in an adult criminal court setting. If passed, the bill would allow, but not mandate, an adult court judge to send a child defendant to juvenile court for more appropriate sentencing if the defendant has proven by clear and convincing evidence that they were the victim of trafficking or abuse at the hands of the person whom they are accused of harming within 3 months of the commission of the offense. Grooming tactics and traumatic bonding, coupled with the fact that children's brains are not fully developed, prevent them from fully understanding the consequences of their actions as it relates to people who have committed severe abuse against them. While children who have been victimized have real feelings of danger triggered by their abusers, self-defense laws don't always protect them because those laws often require a threat of imminent harm. And even though a child feels they're in imminent danger, sometimes they are also premeditated. The fact remains that a child would not have committed a crime if it were not for the abuser having abused or trafficked them, and the law should focus on treatment, not punishment of the child victim. I also want to address the Coalition Against Sexual Assault's concern about these children should be addressed before charging or before adult court. We agree, but there are certain circumstances under the law currently that prevent those children from being transfer eligible. So this would be their only chance to get back to juvenile court. And thank you, Mr. Chair. Urge a favorable report.
Thank you. So I believe we have Ms. Watts to testify next. Is Ms. Watts here?
Thank you.
Please, and then we'll take questions.
My name is Kimber Watts. I'm an attorney with the Office of the Public Defender, where I'm the chief of the Forensic Mental Health Division. We'd like to thank Senator Folden for bringing this bill. It's an important one, and I can't understate that, frankly. I've been representing children for about 25 years. I have experience representing children who are the victims of sexual abuse, who are the victims of sex trafficking in particular. So let me first say, particularly among my clients who've been the victims of sex trafficking, they tend to be groomed from DSS placements, both in Maryland, and the furthest I've experienced personally is California. So you're talking about girls who are brought far from home, who were already vulnerable and have no way out. They were prey, to be blunt. These are children who've been subjected to some of the most extreme abuse imaginable. And my written testimony details how that trauma impacts their ability to think through situations when they are in harm's way. These are children who deserve a second chance to be treated in juvenile court, and the ability to transfer them to juvenile court at sentencing is a huge step in that direction. I just want to pick up on something that the senator said when he was introducing it, and something that Ms. Virgin said. You know, a few years ago, I had a jury trial where this was exactly the issue: self-defense amidst a sexual assault. I don't know how many of you have experience with jury trials, but jurors can ask questions. While they were deliberating, one of the questions that a juror asked was, can you use lethal force to defend against rape? I'm just going to leave that there. Thank you.
Thank you. Questions for the sponsor or the two panelists? All right, seeing no questions, I think we'll go to our virtual testimony. This bill wins the Strange Bedfellows Award this year. This is true. Mr. Harper and then Ms. Doom. Mr. Harper.
Hi. Thank you for allowing me space to actually support Senate Bill 601. I asked for a favorable decision in regards to this piece of legislation. One of the reasons why this piece of legislation is so important to me is because at the age of 17 months, I was placed into the foster care system. Throughout my time in the foster care system, I had experienced multiple abuse of foster homes. By the time of my 16th birthday, I had experienced 48 different foster homes, and I was now being tried for a homicide against an individual who had molested me and my younger brother from the age of 7 all the way until I was 13. I regrettably took his life, and for that I was punished and I was cast away. I was given life without the possibility of parole plus 10 years. I was told that I was irredeemable. I went to prison and I transformed my life. I was commuted by Governor Jerry Brown and then released by Governor Gavin Newsom. Today, I'm the founder and executive director of Better Days. Our mission is to end the foster care to prison pipeline, the same pipeline that I traveled through. One of the ways that I ended up with life without the possibility of parole is I was transferred to the adult court system. My plea is that you guys will value children. My hope is that you will think about yourselves and think about your children. And if you're not parents, maybe your nieces, your nephews, but just children in general. My question, but also my hope, is what would you want done to your child? Or what would you want done to you? My hope is that we would hold children accountable instead of punishing them. My hope is that you guys will support this piece of legislation and protect children. Thank you.
Thank you, Mr. Harper. Ms. Doom.
Thank you for having me today. Dear Chairman Senator William C. Smith, Jr., and members of the Maryland Senate Judicial Proceeding Committee. My name is Sheena Dumais. I am the Senior Public Policy Associate at PAC, formerly known as ECPAC USA. PAC is a national organization committed to protecting all children from trafficking. Today, I stand before you to advocate for Bill SB 601, minors convicted as adults sentencing transfer to juvenile court. This bill represents a crucial step towards justice for some of our most vulnerable minor citizens who have been trafficked and subsequently forced into situations where they commit acts of violence against those who have exploited them. In my role, I've witnessed the complex trauma faced by survivors of trafficking. Survivors of trafficking often carry burdens unimaginable to many of us. When a minor is in a desperate attempt to escape or respond to their trafficker and commits an act of violence, it is a clear signal of their dire circumstances and not an inherent criminal intent. Minors who find themselves in these extreme situations are victims. This bill acknowledges their unique circumstances, offering them a pathway to rehabilitation rather than punishment. Evidence conveys that rehabilitation focuses approaches significantly reduces recidivism rates among the youth. For trafficked victims, the importance of specialized rehabilitation cannot be overstated. It offers them a second chance at life. Support for this bill is not just a legislative decision, it's a moral imperative. It reflects our collective belief in redemption, justice, and the capacity for change. By enacting this bill, we recognize the victimhood of these minors and commit to their healing, reintegration into society. I urge legislators to consider the profound impact your support can have on the lives of trafficked minors, transforming them from victims of their circumstances to survivors with hope for the future. Thank you for the opportunity to speak for those who often don't have a voice. Your support on SB 61 is a step towards a more compassionate, just, and understanding future for Maryland. Thank you.
Thank you, Ms. Dumais. Questions for this panel? All right, seeing no questions, that concludes the hearing on Senate Bill 601. The next bill is Senate Bill 544. That is my bill. Thank you, Madam Chair, and Boy, does that have a nice ring to it, members of the committee. I am presenting Senate Bill 544. Senate Bill 544 is a follow-on on legislation we passed 2 years ago. But let me start with this preamble. Sometimes in this body, we make an inadvertent mistake, and we have procedures by which we undo those inadvertent mistakes. And I think on the floor today, we took something from third reader back to second reader for the purposes of a technical correction, and then we'll move it back back to third reader and move the bill. We do that all the time. Sometimes we re-refer a bill back to committee to fix something technical that we missed as it moved through the process in regular order. Corporations in our state have the same issue. Sometimes they make decisions and have board votes in which they inadvertently make technical mistakes. Those mistakes are then found at some later point, and they have to fix the mistakes in some fashion. In the meantime, even if the mistake nullifies the decision, people have relied on that original decision, and lots of money is often at stake. And so 2 years ago, we created a standardized process by which corporations had a safe harbor to remedy technical mistakes that they made in their decision-making process. And that is what's called ratification of defective corporate acts. It's a fancy way of saying they need a safe place to fix a mistake. We now have had 2 years of that law's enactment, and practitioners have utilized it successfully to help ratify some inadvertent corporate mistakes. But in doing so, they've learned the flaws of that process and come back with a clarification bill, which would allow corporations who make these take these defective votes to remedy them and to do it without a big deal. So, one question that I asked the Bar Association before I put in this bill is, could this be abused for someone who had some kind of malicious intent to get a safe harbor against a mistake that wasn't really a mistake, that was purposely made in order to defraud shareholders or defraud anyone else? And the answer I got back is no, this process couldn't be used for that purpose, because this process is inherently a very public and document intensive one. And so if you wanted to hide something, you would continue the fraud. You wouldn't use the process set up 2 years ago and clarified in this bill. Instead, you wouldn't want to do that because it's a very public act that you're taking under this bill. And with that, I will turn it over to the Bar Association and ask for a favorable report.
Thank you, Senator Walsh-Streicher, and also want to especially thank the committee for their time, and also Senator West for his sponsorship as well. As Senator Walsh-Streicher explained, the enactment that was done in 2022 was indeed a safe harbor, and it is designed to supplement common law ratification methods that are already available to corporations, but lack the certainty that exists with a statutory process. And often this happens, by way of example, a corporate act happens that was done in an effective way, but it's not discovered until years later. Often that discovery occurs when you're planning either new investment or seeking a loan from a bank, things of that nature. And those third parties will often look for and desire more certainty. And so the statutory process creates that additional certainty. So again, now that this has been in practice for 2 years, the committee has reviewed and identified several areas for refinement, improvement that we think warrant an amendment of this nature. The scope of those changes are summarized comprehensively in our written testimony, but just as an example, one of those is things like correcting internal consistencies with other language in the MGCL. Also things like the court process that's laid out in the subtitle, we're specifying that should be a Maryland court, not something that was specified in the initial language. We obviously want Maryland courts hearing these issues. So again, the amendments are clarifying in nature, reinforcing in nature, and trying to make the process more clear and operate with better mechanics. And with that, I'll answer any questions that the committee might have.
Seeing no questions. Oh, there, Senator James.
Thank you.
could you just give me an example of a typical, just because I'd like to understand the bill?
Sure.
Okay.
Absolutely, it's a fair question. In Maryland corporation law, there's a requirement that the corporation has in their charter the number of authorized shares that the corporation has the authority to issue. So that's going to be a number stated in its charter document. And often, as companies are formed and they're moving fast and they're growing, they might not look back at that document. And so it's possible that they did an issuance of additional shares, received consideration from the shareholders, things were approved, but technically the number of issued and authorized shares now exceeds what's in their charter document. And so this might go undiscovered for several years, but then when they go to take another investment from a larger investor, maybe an institutional investor, and that third party diligences the existing capitalization of the company, the shares that have been issued, there would be a technical issue with the outstanding shares versus what's authorized. This process would allow them to point to a statute and say, here's a process by where we can fix this. And the third party can take comfort in that because it's a statutorily recognized process for correcting it. Without this process, corporations are left to sort of deal with that outside of the statute in common law. There's ways to do that, but it lacks the certainty. And so that's the purpose of the subtitle. This amendment is trying to improve that, make it cleaner, make it better now that it's seen 2 years of practice.
I think the bill is perfectly fine. It's not, and I really trust when the Maryland State Bar Association works collaboratively and identifies things that need to be done. I just really wanted to understand it. But one thing that Vice Chairman had mentioned is that there might be situations where there was reliance and significant amounts of money. Do those kind of situations arise, or are these more of the situations you just described? I'm just curious.
I think it could arise, and really, I think part of the problem is sort of the passage of time.
Yeah.
So, in the example we were just talking about with a shareholder that gives consideration, that shareholder, will do things like file taxes as a shareholder, things like that, and so it's not something that you can just necessarily reset.
Yeah.
Because there has been the reliance that Senator Wallstrecher mentioned that, operating as if it was done validly. And so here you're just sort of ratifying that there was a technical error. And you would still, for example, if the action that's being ratified requires stockholder approval, that still needs to be done here. So there's no way to sidestep anything. It's basically going back and saying, a mistake was made. We want to do it correctly and ratify what is technically imprecise.
So in any instance where someone could argue, I would be harmed by this, there's mechanisms to make sure that you work through that process as well, or is that correct?
Sure. If it's a stockholder that's bringing that argument and the action required stockholder approval, in order to ratify under this subtitle, you would need to obtain the stockholder approval.
Okay.
Anyway.
Yes.
However, there also secondarily, there is a process built into the subtitle where if you take the steps laid out in the subtitle, the act is effectively ratified as of the date those steps are completed.
Right.
But there's a 120-day period where the corporation, shareholders, any related parties that have standing could bring a claim to say to challenge that ratification, and then at that point a court would consider it, and they would still have sort of one last chance to correct an alleged wrong.
Or protect people. Okay, thank you very much. I learned
Absolutely.
something. Appreciate it. Senator Signor.
Very much. How is this power intended to work for non-stock corporations? Do you have an example that you could walk me through?
Right. I mean, it's so this would apply to non-stock corporations. There's language that will pull it in to treat non-stock corporations or provide this as a mechanism for non-stock. Obviously, the stockholder issuance example doesn't fit for a non-stock by nature of what we're talking about there. But there's several other acts that could benefit from ratification like this. For example, a non-stock corporation still has a charter and bylaws for how the board or the members, I mean, there's some different language used in that corporate form, take certain actions. And so, for example, if a non-stock corporation took an action that required a certain threshold of board approval, but that board approval was never documented, and years down the road, it can't be verified what approval was given. The board at that later time could look to this procedure or this process now in the subtitle to ratify it and say, here the requisite approval is ratifying that the authority existed and acknowledge the act, and then that would make the act effective and valid with the statutory backing of that, if it was ever questioned.
To which date? And I know you were talking about dates earlier. The date that you thought that the act had occurred, or
sorry, say that again.
It would be effective as of.
So it would become effective. The ratification would be effective at the time that the steps required by the subtitle for ratification occur, but it would give sort of retroactive. It wouldn't. It would close the gap of sort of if there was alleged defectiveness, it closes that gap and brings forward the effectiveness of the act and sort of corrects the mistake as if it happened initially, as if it was done correctly initially.
And you all have, I guess, experienced this real. I mean, there have been real examples or anecdotes of this happening. And
sure, it's definitely not something that happens often, or as a corporate practitioner that I rely on, day to day or often. But it's definitely something that occurs, and usually when these issues pop up, it's at the worst possible time for corporations and stockholders. It's at times where, a bank is considering a loan, and so they're taking a deep dive on the corporate records. And often, some of these initial issuances or things like that might be happening by, business owners that don't have the benefit of sophisticated counsel to kind of walk them through the corporate procedures. And so they're taking acts without sort of ticking and tying the corporate formalities they need to.
Gotcha.
And so that's where it most usually comes up. And because of that, it's often not discovered until a later event where you have, the company's seeking a sale or seeking a large investment or a large loan. And those third parties are now kind of taking a look under the hood. And so that's where we see it most often. It's not an everyday thing, but it certainly comes up.
Thank you very much.
Okay, I don't see any opposition, so that concludes the bill hearing on Senate Bill 544.
Thank you.
All right, hello, welcome. So we have next up Senate Bill 730 with Senator Carter, motor vehicles, motorcycles, and passenger restrictions. Senator Carter.
Great job, Madam Chair. Thank you very much. So, committee members that are here, this is a short and common sense bill. Even some of the nitpickers on this committee may not have anything to say, at least I hope. So, and I wish that the Senator Folden were here because the cross-file of this bill is one of the delegates from Frederick County, April Miller. I'm actually going to incorporate some of her testimony because it was so compelling. She begins her testimony for her cross-file, which is now in this committee. It's already passed the House Bill 102. And she says, many of you may look at me and think she doesn't look like a motorcycle maven. Well, I would say the same thing could apply to me. But so why am I bringing this bill? I'm bringing the bill because it's a common sense bill and it just does a simple thing for motorcycle safety. It simply requires that a passenger on a motorcycle vehicle be able to firmly position the passenger's feet on footrest of the motorcycle. The bill does not apply if the motorcycle passenger cannot position their feet due to a permanent physical disability. There is some data that indicates that we need to have greater protections for motorcycle vehicle riders. And this deals with passengers. We don't have an age limit. Some states have age limits, but what the research shows is that age limits don't always make sense because it's really about the size of the individual and whether they can reach the footrest. And so for that reason, the bill seeks only to require this. There was a story that was put into the testimony out of a Frederick County mother who apparently was divorced and apparently didn't have that wonderful joint custody situation. And so the father, who was merely a visitor, wasn't used to being around the child all the time. It wasn't familiar with all the safety mechanisms. And so what the testimony that was offered by this Frederick County mother is that while she was required to have all of these precautions with the 4-year-old, with the car seat, as soon as she was finished and turned that child over to the father then put that child on the back of a motorcycle with no precautions, no requirement of a footrest, and traveled down this very same road that she in her safe vehicle was required to use a car seat with all of those protections. And so again, it's a common sense bill. I don't believe there's any opposition, or at least I don't see any. So with that, I would ask for a favorable report. Thank you.
Questions from the committee for Senator Carter? Seeing no questions, that concludes the hearing on Senate Bill 730.
Thank you.
I'm still doing, is she coming back? Or, well, let's call up Senator McKay, 503. Thank you all for waiting so patiently. Vehicle laws, protective headgear requirement exception in remembrance of Gary Pappy Boward. I hope I said it right. Do you want to call your panel up or you want to go first?
I'll just go first.
Okay, great.
So Madam Chair, doing a great job. Could almost be like a DJ the way you go, you lead into that microphone there. Madam Chair, members of the committee, I'd like to preference a comment that was made by the committee about a bill that we had just heard. This is going to be a bill that you've heard year after year after year. And I would say that I just asked the committee to have an open mind when the opposition comes and say, I've heard opposition of this bill year after year after year, and you don't seem to come with some form of a compromise. Those who are in opposition of the bill, maybe there's a compromise we can work out this year. So this, and maybe a school bus bill we won't have to hear again. And hopefully we might be able to get this one over the finish line. So yes, Madam Chair, this bill is very special to me. Gary Pappy Boward, who was a constituent of mine, lived in Clear Spring. You may have seen him roaming the halls for, I don't know how many years, 35 years? Longer? Since 93. And Pappy had the long white beard, and he would walk through the halls and through the offices. And really, there really was not an elected official who didn't know who he was, knew that he was kind-hearted, and like anything in life, we shouldn't judge a book by its cover. And a very multifaceted young man. He was in a band, a great singer, drums, and some different things about him that I got to know. And so we did name this bill that you have seen before in remembrance of him. So Senate Bill 503 allows motorcyclists to have a personal responsibility when they're safely by creating specific criteria for adults regarding whether they wear a helmet. Now, an individual must be 21 years old or either, have been licensed to drive a motorcycle for the last at least 2 years, completed a motorcycle course, safety course, and has been approved by the state of Maryland, or is a passenger on a motorcycle being driven by an individual already meeting these previous mentioned criteria. This particular bill does have the backing of the AMA, the American Motorcycles Association, and ABATE of Maryland. You see, mandatory helmet laws alone do not prevent crashes, nor do they prevent injuries. Education and better skills are the best measures to reduce accidents. Mississippi has a mandatory helmet law, but yet has the highest death rate for motorcyclists in the nation. Both Delaware, Pennsylvania do not have mandatory laws, but yet Pennsylvania is one of the lowest for accident rates. Only 0.96% of all registered motorcyclists have gotten into an accident in the years 2021. You see, 3 states have 100% freedom choice. 30 states have age restrictions, and 18 states have helmet mandates, Maryland being one of them. The interesting data that I'd be glad to give to you does not support the opposition testimony you're going to hear. But our data is simple. It's in black and white. Freedom of choice states, 5.04 fatalities per 100,000 registered motorcyclists. States like Maryland, who have mandatory helmet requirements, 2% higher, 7.07. So if the data you would hear is going to save motorcyclists' lives, then why would freedom of choice states have a lower percentage? We present this in honor of you, Gary Pappy Boward. Again, a friendly face in Annapolis from the 1980s up until a few years ago when it passed. He was a major advocate for the motorcyclist rights, and I proudly present this bill to you again. I thank you very much and look for a favorable report. Thank you.
Thank you, Senator McKay. Any questions for the sponsor of the bill? Senator James, thank you.
A nitpicker about to ask a question. No way, Jose. And actually, you can get back to me on this. I did read through this file and thank you all because I thought this was great information. And I appreciate you taking all the time to address what you've heard over the years as opposition. I didn't get this from the file, but I just had a question that anybody can address, the sponsor or someone later. I was wondering about not so much between death and not dying from that, but whether or not the goal of some helmet advocates is to reduce the amount or potential for catastrophic brain injury. So you wouldn't be dead, but you would have. So in other words, the idea behind it is to mitigate that, just head injuries. Do you have data on that at all?
So I will bring in a story and if we do have data, we'll get you the
yeah,
data
you can do
later.
that later
But
for sure.
we had another bill here just a couple weeks ago where we were talking about mandatory helmets for children who are riding horses. And in that testimony, I actually asked the question at what speed does a helmet have an actual ability to help?
Right.
And it was 35 miles an hour. Now the horse, unless it's a thoroughbred, is going to do 35 miles an hour. But the reason I asked that was to talk about helmets, and they are not rated for more than 35 miles an hour. Nowhere in the United States are they rated for more than 35 miles an hour. Now, I'm not advocating for the, excuse my French, the rock rocket type motorcycles that are going crazy. Okay, I'm talking about motorcycle enthusiasts who are actually obeying the laws of the state with the. So if the helmet is not rated more than by 35%, while the helmet will help, but the reality is the injury is not necessarily the helmet, but where the motorcyclist comes in contact with a truck or an automobile and those type of things.
Right.
And so I appreciate the question because it drills down to where the opposition is. I tend to believe that if people could divorce them from themselves, I would say that a lot of people who have opposition to this bill is not so much the helmet, but they wouldn't ride a motorcycle to begin with. So they believe riding motorcycles is probably not as safe as riding in a car and those type of things. So I think it's important to have that part of your deliberations when you think about this. And from a data standpoint, I'll work with them to find something for you,
And can
Senator
you just
James.
clarify very quickly, when you say not rated, I'm kind of following like, okay, maybe they make no warranty of protection over 35 miles an hour. Maybe that's what that phrase means. Not saying they don't help at all over 35, but maybe no. Is that what that means? Not rated means, look, we're making no promises about what this helmet could or could not do over the 35 mile an hour limit. That's where we are. Is that what that means?
There's no industry that will rate that helmet more than 35 miles an hour.
Okay, thank
And so therefore, you can have the helmet or not have the helmet. I tend to believe there is some protection with that because we don't know how the accident happened. There's a variety of things that go in to it. But at the end of the day, they're not willing to say that it's going to help you above 35 miles an hour.
Yeah.
I think that's significant when you talk about the accidents that could occur.
I think
But
it's
thank you.
revealing. I do
Thank
think
you
it's
for the
revealing.
question.
Thank you.
Any further questions for the sponsor? Seeing none, let's go ahead and call up the panel of proponents. We have Ken Eaton and Robert Spanberg. And whoever would like to go first, go right up to the podium.
Thank you, Madam Chairman, members of the committee. My name is Robert Spanberg. I'm the chairman of the board for ABETA Maryland. We're the state's largest and arguably only motorcycle rights organization. I became chairman of the board upon the passing of Gary Pappy Boward, whom this legislation is named after. I guess I should start out by saying that prior to 1966, there was no helmet legislation of any kind in the United States. And in 1966, Maryland, along with a handful of other states, actually made helmet use mandatory through the work of people like Pappy and other members of charter members of our organization. In 1979, we were granted freedom of choice as far as helmet use is concerned. And for the next 13 years, we were able to exercise that freedom of choice. 1992, mandatory helmet use was reinstated. And as you know, everyone, I don't know the last time any of you all have seen anybody running down the highway without a helmet on, but I greatly respect the medical community and their dedication to coming down here and testifying against this legislation. I guess that's the way they feel about it. But as the senator said, I think if you pressed many of those same medical members, they would advise against riding a motorcycle at all. And we realize the inherent danger of it. But most of the close relationships I have in my life are around motorcycling. It's definitely been a joy of my life. I respectfully request that y'all would give this bill 503 a favorable reading. I also appreciate y'all's time for when we came around the lobby in behalf of this to actually listen to us and speak with us. If you have any further questions, please feel free to fire them at me. Thank you.
Thank you so much. Next.
Good afternoon. Say Chairman Smith, but he's not hanging out. Vice Chair Waldstreicher and members of the committee. My name's Ken Eaton. I'm the Executive Director of A Beta Maryland Incorporated. We have bipartisan Western Maryland, Eastern Maryland, Central, Baltimore City, and Baltimore County sponsors on this bill. There's people from all parts of the state. You have my written testimony, but today I'd like to talk about the people that are behind it. Some of them are actually behind me today. We've had a little attrition due to the length of the day and other issues, but if you all could stand up for just a second. They come from everywhere, mountains to the ocean. We've got people from Western Maryland, the Eastern Shore, Southern Maryland, Central Maryland. They're here because they're concerned about this bill. None of us gets paid to be here today. We are bikers. Many of us have been around motorcyclists for all of our adult lives and much of our childhood. We work on them, build them, buy them, sell them, but mostly we ride them, not just around the block, but all over the country. We attend leadership and legislative seminars, meeting of the minds. We network with industry partners. We coordinate with national motorcycle organizations. We take part in roadway safety summits. We are the motorcycle experts. Our membership includes everything from doctors to manual laborers. We all love motorcycles. We are bikers. We ride to meetings, go on benefits and charity rides, ride to work, ride on vacation, clean them, work on them, and talk about them when we're not riding them. I have friends around the world that I can reach out to just to talk about motorcycles. They bring us together. Lastly, I would like to talk about motorcycle accidents. Not one helmet has ever prevented an accident. Training and education have prevented many. I see my time's running short, so I'll run just a little bit. I have many more friends that have died from COVID, heart disease, car accidents, and construction falls than have ever died from a motorcycle accident.
Thank you for your testimony. Do we have questions for the proponents of this bill? Seeing no questions, thank you so much for being here today. We're going to move on to the opposition. I think we have 8 people signed up in opposition. Cliff Mitchell, Brian Pugh, Omar Masood, Leah Walton. Are you all here? Go ahead first. Whoever wants to go first can go up to the podium. Thanks, Cliff.
Good afternoon, Madam Chair, Vice Chair Waldstreicher, members of the committee. Happy late afternoon, and thank you for your indulgence. I'm Dr. Clifford Mitchell. I'm the Director of the Environmental Health Bureau at the Maryland Department of Health, and here testifying on behalf of the department respectfully in opposition to Senate Bill 503. Senator, I do want to get to your question specifically on traumatic brain injury, and maybe I'll go back, but I did want to emphasize, you made a very good point. We know not only that helmets reduce the risk of dying in a motorcycle crash by 37%, according to national statistics, but the risk of traumatic brain injury is actually decreased by 69% in helmet wearing versus non-helmet wearing individuals. When you consider the cost that not only fatal crashes engender, but also the long cumulative costs of traumatic brain injuries, this is one of the reasons that the National Highway Traffic Safety Administration has estimated that universal helmet use would result in $7.2 billion in comprehensive cost savings annually. To conclude, we know that helmet laws work. We know that they decrease mortality. We also know that they decrease traumatic brain injury and save lives. So respectfully, I urge an unfavorable report by the committee, and I thank the committee for their intention.
Good afternoon, Madam Chair and Senator Vice Chairman Wallstreicher, sorry. My name is Brian Pugh. I am the Executive Director of the Brain Injury Association of Maryland. 40 years ago, we were founded by family members and healthcare professionals to serve as a resource for Maryland families struggling with brain injury. We asked this committee to give an unfavorable report to Senate Bill 503. In the early 1940s, long before the interstate highway system, my grandfather, Samuel Boy Steen, a lifelong Harley man, rode his Harley with a suicide shifter. He called it a jockey shifter, all the way from Macon, Georgia to Los Angeles, California, and back with goggles, gauntlets, and the leather helmet of the time. He remained a Harley Davidson man and rode and worked on motorcycles his entire life. In college, my freshman year, my resident assistant had a Yamaha 350. He looked to sell, but let me ride it on the weekends around campus and around the mountain roads of Greenville, South Carolina. It was a blast, and yes, I wore a helmet. I understand the thrill of motorcycles and the devoted lifestyle surrounding them, but I also understand the devastating effects of the motorcycle crashes have on Maryland families. Through our 1-800 number, 800-221-6443, we've spoken to over 50 families and individuals who acquire their brain injuries through motorcycle crashes, lifelong disabilities, cognitive impairments, mental illness, emotional distress, financial burdens on the individuals, the families, and most of these crashes discussed the riders were wearing helmets. Allowing riders to forego helmets not only gambles with their lives, but also the lives of passengers, loved ones, and the others on the road. The bill undermines years of progress in promoting motorcycle safety. We have a responsibility not to cater to a false sense of individual liberty that ignores the devastating consequences of preventable head injuries. We ask that you vote against this dangerous bill and give an unfavorable report to Senate Bill 503. Thank you.
Good evening, Madam Chair, Vice Chair Wallstreicher, and committee members. I'm Omar Masood, the Director of Government Relations for Advocates for Highway and Auto Safety. We are an alliance of various groups that are dedicated to promoting traffic safety in the United States. I appreciate the opportunity to testify in opposition. 2021 set a record for motorcycle fatalities in the US, and the estimates for 2022 show a 5% increase. Motorcycle riders are nearly 28 times more likely to die in a crash than passenger vehicle occupants. In Maryland, 75 motorcyclists lost their lives in 2022. In addition to the physical and emotional toll of motor vehicle crashes, they cost $9 billion annually to Maryland, which equates to roughly a crash tax of $977 on each Marylander. Repealing the law would be a costly and would be deadly. Laws requiring all riders to wear a motorcycle helmet are effective and life-saving. In states with all rider laws, helmet usage is 86%. In states without them, it is 53%. Experience from states that have repealed their all rider laws have shown the consequence of doing so. Motorcycle deaths in Michigan were 60% higher in 2021 compared to prior to repeal in 2011. Missouri experienced a 567% increase in helmetless motorcycle deaths in the first full year after repeal. Moreover, minors-only laws are not only ineffective, but they are difficult, if not impossible, to enforce. To prevent more tragic deaths, lifelong and debilitating injuries, catastrophic costs, and preventable anguish of Maryland families, we urge an unfavorable vote. Thank you for your time.
Good afternoon, Chair, Vice Chair, and members of the committee. Thank you for allowing the NTSB, National Transportation Safety Board, to testify today. My name is Leah Walton. I'm a resident of Montgomery County, Maryland, and a passionate safety advocate who has seen the impact of road fatalities through my work at NTSB, the National Highway Traffic Safety Administration, Mothers Against Drunk Driving, and through volunteering with Montgomery County Families for Safe Streets. One constant that I've seen in my work: motorcycle crashes happen fast, often in the blink of an eye. Some motorcyclists pay the ultimate price. In 2021, 77 motorcyclists died on Maryland roads. Nationwide, almost 6,000 died. Others survive, but can have life-altering injuries. One study found that costs for unhelmeted riders injured in a crash were about 4 times higher than for helmeted riders. An unhelmeted rider is 3 times more likely to suffer a traumatic brain injury in a crash. The best protection is a helmet that complies with the federal standard. Yet Senate Bill 503 will allow Marylanders to ride without protective gear, resulting in more dead motorcyclists and more motorcyclists with brain injuries. Count on it, we have the data. In 2020, Missouri repealed their helmet law, and they saw a 40% increase in motorcyclist fatalities in the first year of their law change. The bottom line, universal helmet laws save lives, reduce injuries, and avoid unnecessary costs. We have such a law in Maryland. Do not throw it away. Keep Maryland's helmet requirement. Thank you.
Thank you for your testimony. We have a question from Senator James. Whoever she directs the question to, make sure to go up to the podium to answer so the AV
Yes,
gets here.
awkward.
Senator James.
Thank you. Not now, it's late, but the proponents of the bill gave quite a lot of information in a packet that hopefully you all have seen or you could gain access to. And what they did was they were comparing, I believe, states that do not have helmet laws to those that do. A lot of them, I think the comparisons were involved Pennsylvania, Delaware, Ohio, Indiana, and Illinois, as I think free states, as they call them, versus Maryland, Virginia, North Carolina, West Virginia. The point of their data over a series of years from, hold on, let me just, in case you don't have it, from about 2021 back 4 or 5 years, was their data at least shows that percentage fatalities are almost always lower in the free states versus the helmet states. I think that's too big of a question right now, but I read it and I'd like to get some response from you all, and I or this co-sponsor of the bill could probably get you copies of it. I just want to know what your response to that is, but don't do it now, it's late. All right, thank you.
Excellent. Senator McKay has a question.
I just have one question. Anyone from the panel can answer that. Just asking what your opinion is on convertibles. Why in Maryland, we don't require someone to wear a helmet who's driving a convertible.
But would they not also, just to answer would they not also be required to wear a seatbelt?
I'm not saying that they wouldn't, but they would, if they were complying with Maryland law, they would, yes.
Okay. So that would be my thought, is that the convertible would have a seatbelt. So.
Interesting. All right, thank you.
Any further questions for this panel of opponents? Seeing none, thank you so much. We'll call up the last panel. We have Justin Graves, Lisa Tenney, Matthew Levy, and Kathleen Hoke. Who's left standing? Good job. Whoever wants to go first.
Hi, my name's Lisa Tenney. I'm with the Maryland Emergency Nurses Association. Good day, and thank you for always supporting nurses. You guys are awesome. I'm here in opposition to this bill again. And I do want you to know that many of my nurse ER friends do ride motorcycles, have the full outfits, the gloves, the helmets, everything leather, and they are very enthusiastic about this. When I told them that I was testifying, they said, please tell them to wear their helmets. I don't want to have to take care of them. So that's my message. So I did want to say that we did submit some written testimony along with the advocates for auto and highway safety, along with Smarter, the motorcycle organization. But I had another thought that I wanted to kind of pass along to you. For motorcyclists, according to my friends who ride, this is an emotional issue because as Americans, they want their freedom to make a choice to take a risk. And they want the freedom to have an enhanced riding experience without having to wear a helmet. And while I get that and I respect it, when you weigh that against the risk and all the negative things that happen, it's like a no-brainer, just stay the course. This is also an emotional issue for every trauma nurse. Not because it's difficult to take care of a trauma patient. I mean, we love that, we're adrenaline junkies, but the emotional part is when we have to deal with the families. And I think I'm out of time, but I just want to add that if we keep this bill, it's one of the easiest ways to get to zero vehicular related deaths. Thank you.
Madam Chair, Vice Chair, and committee members, thank you for the opportunity to present to you today. I am Prince George's County Health Officer, Dr. Matt Levy, and I am here on behalf of the Maryland Association of County Health Officers to express our strong opposition to Senate Bill 503. Data, as you've heard from health and traffic safety experts, is clear. Helmets reduce the risk of death by 37% and the risk of head injury by 69%. Helmets do not limit a rider's ability. Universal helmet laws save lives, prevent injury, and save money. This is not true of partial laws. If age equals experience, experience does not mean less fatalities. Nationally, riders 30 years and older account for over 70% of all motorcycle fatalities. More riders over the age of 50 died in 2019 than riders under the age of 30. Non-helmeted riders injured in a crash have substantially higher healthcare costs than helmeted riders. In 2017, the motorcycle helmet use saved Maryland $100 million in direct economic costs and over $590 million in comprehensive costs. When a non-helmeted rider crashes and is injured, many are impacted and traumatized, not just the rider. This includes the EMTs who arrive on the scene, the medical staff who try to save their life, family members who have to care for their loved ones or have to say goodbye, and many others. For these reasons, MACHO strongly opposes Senate Bill 503. It is regressive, and if passed, will take us back to 1979, when the helmet law was repealed and lead to increased death and injuries until it was reinstated in 1992. Now is not the time to revisit the past failure and change what is working for our communities. We ask for an unfavorable review of this bill. Thank you very much.
I don't know if we can say evening yet, but good afternoon, Madam Chair, Mr. Vice Chair, members of the committee. My name is Justin Graves. I'm the Director of Trauma Programs at the Artemis Cali Shock Trauma Center. Our mission is to not only provide care to those that are critically ill or injured, but also to actively engage in efforts to prevent traumatic injuries through our Center for Injury Prevention and Policy. Shock trauma, designated as the primary adult resource center and as the state's neurotrauma center, sees the harsh realities of traumatic brain injuries every day. In FY23, shock trauma cared for over 2,600 individuals with traumatic brain injuries. This volume of patients not only allows our trauma teams to develop the clinical excellence in managing the traumatic brain injury, but also allows our team to gain the equally important expertise helping patients and families navigate the wide range of life-altering disabilities resulting from these injuries. Within the Center for Injury Prevention and Policy, we dedicate a large amount of resources toward the prevention of motor vehicle and motorcycle involved collisions. And just like promoting safe driving behaviors such as seatbelt usage or advocating for helmet use is a fundamental and evidence-based strategy in the prevention of traumatic death and injury. Fortunately, Maryland has been an early adopter of effective public health policies, including helmet requirement laws. These laws have undoubtedly saved lives, prevented numerous devastating injuries, and the consequences of repealing the motorcycle helmet law is clear: more lives lost, more families impacted, and more strain on Maryland's trauma system resources. So I urge this committee to continue to prioritize the safety and protection of all Marylanders and provide an unfavorable report for this bill. Thank you for your time.
Thank you. Questions, Senator McKay.
Sir, from the trauma, if you would, please. Of the 2,600 motorcyclist trauma that you were talking about, of those 2,600, did any of them pass just because of brain trauma, or was there actually more damage or equal damage or some damage to the rest of the body?
So those are how many people suffered from traumatic brain injuries, not necessarily died. I don't know if that's,
Okay.
was it, just to clarify. I don't have the data in front of me, but it's fair to say that many of them have other injuries associated.
Yeah,
other
that's
than
and
just
that's just trying to get to my point.
Yeah.
It seems to me that, you know, while it is a question of having choice, and if we did have the choice, those who wanted to continue to ride with a helmet still could do that. I know that wasn't your testimony, but that's just a statement from there. I would be interested to know, of the 2,600 brain trauma, did any of them have nothing else that was of the body that was in trauma, but because of a helmet or lack of a helmet, it was only the body? What I'm trying to get, or is only the brain. I'm trying to get at is, I appreciate everything that you do at shock trauma and saving people and that kind of stuff, but to say when an accident happens that it's the helmet, and I tend to believe it's the overall injuries to the whole brain, the whole body, that actually unfortunately have people succumb to death.
Yeah, I mean, I don't have that specific data in that breakdown as you're asking for it. I mean, I think the panelists before me testified with a lot of the statistics. I think what's also relevant is what the patients that we don't see, that never come to shock trauma because they're just dead on arrival for EMS too. So, you know, it's evident to anyone who works at shock trauma. You ask them that the patients we care for who were or weren't wearing helmets, and the varying injuries that we see, certainly patients die who do wear helmets, but we know from the evidence that does reduce the likelihood and the severity of injury that we have with the patients.
Thank you, sir.
All right, any further questions for the opposition? Seeing no questions. That concludes the hearing for Senate Bill 503. The last bill today is mine. It's Senate Bill 593. And so I'm going to come on up. Senator James.
You may have missed, I sent you a couple of emails about
Good evening, Madam Chair, members of the committee. Senate Bill 593 is before us now. For those of you who've been around a long time, you've seen a stark change in the approach of our State Highway Administration, better known as SHA. And while it's not perfect, over time SHA has integrated all users into their designs of roads. That means bicyclists and pedestrians, folks in wheelchairs as well. And that's been an important change. And again, we're not there yet, but all of us work frequently with our friends at SHA to make sure our state highways in our legislative districts are accessible to all. The same cannot necessarily be said about our friends at MDTA. And there's a reason for that. These guys are bridge builders and light rail operators, and the safety of these large infrastructure projects are critical. And so it makes sense that they're not necessarily focused on pedestrians and bicyclists, but the time has come to try to integrate that thinking into their thinking and do so in a way that's workable and flexible for them. And that's what Senate Bill 593 does. under current law, MDTA, when they create a new toll facility like a bridge, like an ICC in Montgomery County, like a light rail system, they are allowed to, but certainly not required to, consider pedestrian, bicyclists, and other road users when designing those projects. So the default is that they don't. And this bill flips the script. What it says is when they are designing facilities for public use, they shall consider pedestrian, bicyclists, wheelchair users, and in fact, all users when designing these facilities. Now, let's be clear. Not all facilities should be utilized by all users, and this bill does not mandate that. But what it does is by flipping the default, it means MDTA has to create a specific finding when they decide that it is not safe for pedestrians, bicyclists, or other users. The bill also creates a small, essentially, board of advisors to help them make that decision and advise on whether a new facility is or is not appropriate for all users or just cars. And that's it. That's what the bill does. I think one of our witnesses was the sidewalk victim we heard about earlier, but fortunately we have two other witnesses here who can talk about why this is critical for all user safety, especially bicyclist safety. Thank you, Madam Chair.
Well, thank you for bringing the bill, and we'll hold questions until after your panel has spoken.
Great. Thank you, Madam Chair, Vice Chair and Sponsor Walt Stryker, members of the committee. John Corrin, Bicycle Advocates for Annapolis and Anne Arundel County, but today speaking on behalf of a broad coalition of local, state, and national advocates. What's behind this bill is that MDTA has an unfortunate track record of promising facilities and then pulling them away when the project is constructed. The ICC was promised to have a parallel shared use path along it. When construction came, it was taken away. When the governor announced the Nice Bridge replacement, it was announced to have a separated bike ped facility, as most major bridges across the United States now have. And we provided a list locally that would include the Woodrow Wilson Bridge, the newer Frederick Douglass Bridge. It was taken away on the Nice Bridge. In 2018, when the legislature passed the Complete Streets bill, it included all of the modal agencies of MDOT, SHA, MTA, even the airports and the ports. MDTA got themselves crossed off. Interstates are often barriers to people traveling on bike or foot. And in fact, the federal government has a grant program called Reconnecting Communities to provide safe crossings across interstates that have divided communities. Here in Maryland, we have waterways that we love, that are treasured, but they are barriers to people traveling on bike and foot. So we want MDTA to have a policy, as Senator Walt Stryker said, that aligns with the rest of MDOT, and to provide facilities where they make sense, have a waiver for places where they just don't make sense. I will say I spoke yesterday to the new director of MDTA. We feel there's a new level of collaboration and dialogue, and are wanting to work with him to get this bill right, but we would like to see it in statute. Thank you.
Good afternoon, Mr. Chair, Vice Chair. My name's Larry Zarzecki. I'm a retired state trooper. I'm a retired state trooper, and I'm also a volunteer for AARP Maryland. AARP Maryland represents approximately 850,000 Marylanders age 50 and older. This bill makes sense. This bill makes sense because we can have access over waterways, and living on the Eastern Shore in Queen Anne's County, a perfect example is Kent Narrows. Kent Narrows runs parallel to a high-speed highway, has proper buffering, runs parallel to Route 50, has appropriate buffering, and the Cross County Trail is approximately 12 miles long. It's very safe. It actually crosses a bridge. Think about that. It crosses the Old Kent Narrows Bridge. Speed limit's 40 miles an hour. There's never been an accident that I know of because there's proper buffering. It's environmentally safe. It's environmentally sound. It's healthy. Seniors enjoy it. I've seen people on electric wheelchairs, electric scooters, electric bicycles, pedal power bicycles, push scooters, skateboards. They all utilize the bike lanes that are properly buffered across the Narrows Bridge. Now, people come across the Narrows Bridge for shopping, for medical care, for their faith-based religion issues, which isn't available easily in Graysonville. For that reason, I would like to ask that this committee find a favorable decision in this bill. Thank you very much.
Thank you, Senator Walsh-Raker, for bringing this bill, and I'm very supportive. I hope you'll let me co-sponsor it in the future if we don't get it through. I live in Haverty Grace, and I have the Hayden Bridge, and years and years and years of frustration with opportunities missed because we have not provided that access, and it is holding up the whole East Coast, is it not, gentlemen?
Yes.
So I'm all for this. I just want to understand one thing in the bill. Anybody can answer it. Are we trying to say that existing bridges and tunnels would also begin to allow for bicyclists under certain and pedestrians under certain circumstances? I only say that because I do worry that we haven't designed any of them to be safe. Bicyclists in my area think, no way they're going to go over the Hayden Bridge. Well, you have to push a button there. They don't even have a satisfactory route, but it's very, very dangerous.
I've done it precisely once, and
Right,
that's
right.
enough times.
Yeah.
For me.
It's horrible.
Um,
So I'm worried about just that provision. I'm very interested in prospectively or retrofitting or adding to make them safer and really meaningfully be able to cross them. But I'm a little worried about trying to do it without all that.
Completely agree, Senator. Yeah, I mean, the real spirit here is the best time to do it is when it's being designed and constructing a new bridge. So if we ever get a new Susquehanna crossing, including a rail
And the
crossing,
rail crossing.
if we
right.
get a new Chesapeake crossing, it should include a separated bike ped facility, like long bridges, like the
Right.
Tappan Zee replacement, and
Right.
the Pensacola Bay
Yes.
Bridge, American Legion Bridge. It should be designed in. There may be times where there's smaller bridges are retrofit or
Yes.
during maintenance, but putting it like on the Hayden Bridge, MDTA did the best they could do on a bridge that has no shoulders, there's just really no space.
I only use
So-
that as a great example of how bad it is.
Yeah,
Right.
no, the spirit of this is to get it designed in when it's also the least expensive time to get it incremental to a whole new bridge.
And I would support this bill if it says a priority is to retrofit them. The only hesitancy I have with the bill is to do it without that additional language.
And we know as
would not
a
object to-
practical matter that,
Right. so
that's
you
the way
wouldn't
it's gonna
object to
go.
Us noodling with that language a little bit to
Not-
make sure it,
No, not at all.
clarifies
The agency has fiscal concerns and
well, of course they will.
yeah.
But that's, we're speaking our priorities. here.
Yes,
Thank you
yes,
very
indeed.
much,
Thank you.
all of you very much.
Thank you.
Thank you, Mr. Chair. So could I ask the sponsor of the bill a couple of questions? Not long, because it's late. As I understand it, our committee has something in the range of a $250,000 limit to bills we can pass without getting special approval from the Budget and Tax Committee. This bill has an $8 billion fiscal note. Have we gotten approval from the Budget and Tax Committee to pass this bill?
We will.
That is the most epic exchange ever, because I was thinking the same thing, but I didn't have the gumption to ask the question.
You know what I mean? Let's just go forward. So let's talk about specifics. I would feel much more comfortable if this bill said a particular project that's coming up needs to be designed with this rather than this across the board scheme that anytime maintenance is done on a bridge or a road, you have to talk about redesigning the bridge to provide for buffered bike lanes. So we had the situation of the bridge across Route 301 and the Potomac River, where the original proposal, I think, was to include a bike lane, but they concluded that the cost of the additional bike lane was going to be astronomical and decided not to put it on the bridge. Wouldn't it have been better for us to have weighed in at that point and said that it's the sense of the General Assembly that we think a bike lane should be added, if that in fact was our sense, even despite the extraordinary price tag it would cost, rather than pass this bill?
Yeah, so I'm not averse to that idea, but I think what the bill does, the reason it takes the tack that it does is because we're trying to incentivize but not mandate a change in culture, as opposed to doing it project by project. Just as SHA now, we don't put in a bill that says, hey, Georgia Avenue needs a bike lane. We allow SHA to regulate their system as they see fit, but we pass legislation frequently to try to incentivize them to include other users. And so, we're going to have larger conversations about this bill in this agency. And as you heard from the advocates, I think the agency is slowly but surely moving in the direction that everyone wants them to move in. I think the idea here is let's better create a culture where all road users are thought of from the beginning of the project to its completion.
Okay, and my last question deals with the roads, with the shoulders of the roads.
Yeah.
I mean, there are lots of state highway run roads in the state with very high speed limits. I'm thinking both beltways, the Baltimore Beltway, the Washington Beltway, Interstate 95, the Harbor Tunnel Thruway, the Harbor Tunnel itself.
Right.
The Fort McHenry Tunnel. And some of these have shoulders where I think it'd be highly unsafe to have pedestrians walking along, say, the Jones Falls Expressway.
Right.
So how do you marry those concerns with this bill, which seems to express the preference that the State Highway Administration arrange for people to walk or bike along these particular highways?
Please go for it.
Sure, yeah.
Yeah, thank you for the question, Senator West. We don't envision very often a place with speed limits above 50 miles an hour where cyclists would be permitted. But there are places where the only way to get from A to B may be to utilize a short segment of shoulder. And case in point is on Route 32 near Route 32 in front of Fort Meade. Between Route 175 and 198, there's about a 3-mile stretch where it's the only way to travel east-west. Otherwise, you've got to go all the way around the top of Fort Meade or all the way around the bottom of the Patuxent Wildlife Refuge. So they are permitted and it's signed there. We expect that to be only by exception where there's some compelling reason and it's deemed safe. We are not looking for bike riders on I-95.
Okay, and then my final question relates to road work. So it's not unusual on these high-speed highways for the road to be pinched because they're doing work on the sides or bridges or something along the way. And the cars on the vehicular lanes are squeezed down. What would happen if we had a bike lane along the side of the road and they had to work on the road? Would they have to dedicate one of the vehicular lanes to bikes so that all the cars are squeezed into a single lane, causing multi-mile backups behind that? How would that work?
Yeah, usually there'd be a detour over on a bridge or someplace like that. It would probably be closed to bicycle traffic for that time. I will say though, one of the advantages of a separated bicycle pedestrian lane, and I mean fully separated with a vertical barrier between the cars and the bikes and peds, is that can be a maintenance lane and that can be an emergency access lane. Those lanes are wide enough. If you ride across the Woodrow Wilson Bridge, that's wide enough for a truck or an ambulance or to get through if need be.
I will say I noted on at some submittal that in New York City, the George Washington Bridge and the Brooklyn Bridge
Yes.
seem to have dedicated bike pedestrian lanes. I walked across the Brooklyn Bridge once, but it was on an aerial pathway above the vehicular traffic lanes. It was a great experience. So if we could do it at a reasonable cost, I'm all for it. Thanks.
Thank you.
I signed up for a half marathon in the Brooklyn, run over Brooklyn Bridge after session. If you want to run with me, that'll be fun. Let's do it. Let's do it together. All right. Thank you both very much. Appreciate it. Thank you. With that, that'll conclude the hearing for Senate Bill 593 and the hearings for the day. We have voting tomorrow at what, 9:30?